we've scheduled for today. This is the second public meeting we've called to discuss the proposed pole attachment regulation at the Public Service Commission. And hopefully everybody to whom I've sent an invitation has had no problem getting on. I do not see any of my emails indicating otherwise. And if people come on along the way, then we will let them join in our festivities. Last time I went through and called roll. I'm not going to do that at this moment. We'll do that shortly. I just want to say, for those that do speak, please state your name and the party that you represent. It'll help us keep good notes and to follow these. Realize where parties are coming from. So that being said, I have a list of the people that I sent out, and I'm going to call a quick roll just to make sure that everybody is on here. And so without further ado, from I think representing the rural electric co-ops in general, Chris Perry, I can see you there. Morning, Chris. And Tip, I see you somewhere on one of these screens. Is Sean Knowles on?
Yes, I'm here.
Morning, Sean. From Clark Energy, is Todd Payton on? Okay. What about from Bluegrass Energy, is Greg Harrington on?
Yes, I am.
All right, thank you. And from Duo Broadband, is Mark Henry here?
Yes, I'm here.
All right, thank you. CTIA, is Matt Tatura on? I see you there. Okay, gotcha.
Yes, sir. Thank you.
From T-Mobile, is Bill Haas on? We'll see if he can come on. Miss Honecker, I see you there somewhere. Jeremy Gibson, you're on there. I see you. What about Jared Routh from Shelby Energy? Okay. How about Jeff Hahn from Kenergy? Okay. What about Pam Ellis from Kentucky Power?
Here.
Oh, there you go. Sorry. And Eric Langley, who I think is here on behalf of both LG&E. I see you, Mr. Langley.
Good morning. On behalf of LG&E, KU, and Kentucky Power.
That's right. And Mr. Keller, on behalf of Charter, I see you there. And Ms. Valenstein, I think I saw you there. Good morning.
Morning.
Mike, I know, yeah, I'm not going to even try with your last name again. I think I got close last time. I'll just leave it at that. What about Mr. Bast for Charter? All right. Do you know anybody from Charter? Do you know if Mr. Bast will be joining us? He's I believe, the manager of construction.
I believe he will,
Okay.
but he may be just a few minutes late.
Right, that's fine. 2021 is not much different than 2020 in the way things are working. Mr. Werner, are you here?
Yes, sir, I'm here. Good
All right.
morning.
Got you there. And then Jim Garner, I saw you check in somewhere on there, so good morning.
Good morning.
Chairman. Ms. Judd for LG&E and KU, I think I saw you log on. No problems this morning. Mr. Lovecamp, I saw you. And Mr. La Follette, I think I saw you on there. Yeah, there you are. Okay.
Yep, we'll call it.
Right.
Good morning.
Good morning. All right. Do we have anybody on for AT&T? Mr. Tyler, Mr. Schwartz, or Mr. Reinhardt?
Dan Reinhardt is here.
All righty. Mr. Schwartz, Mr. Tyler, are you on yet? Okay. And then for Nolan Rural Electric, is Mr. Lee on? Mr. Woosley?
Yes, I'm here.
All right, thank you. Mr. Jones? Mr. Denny? And Ms. Coffey? Okay. And I will send it, I beg your pardon?
Yeah, good morning. It's John Tyler. For whatever reason, I'm having difficulty in audio via the computer link, so I can see what's on the screen, but I'll be using my cell phone and for audio.
Okay, and that's not an uncommon problem, so, good morning, Mr.
This
Tyler.
is Sarah Judd. I've just joined. Apologies. I was having some problems as well and got kicked off, but for now, I'm on.
All righty. Good. I thought I saw you earlier, Ms. Judd, so I'd marked you present.
Thank you.
Let's see, and so for Brandenburg Telephone, is Dre Willoughby on? Or Allison Willoughby? I beg your pardon? All right. What about Allison Willoughby? Kelly Roberts? Randall Bradley? Chris Cornett? Or Brent Jerkins? I'm sure some people might be popping on later on today, or we'll see when they join us. But anyway, that's the list of people to whom I sent the invitation. I also want to say that we have 2 staff members on. One is Ben Bellamy, who really will be running the show, and CJ Mance is also an attorney with the PSC, who will be watching this. The invitation was also sent to our commissioner, Talina Matthews, and she may be watching and may be participating. So just know what you say. There is a commissioner watching. That's the assumption I always make whenever I speak at the commission, so it's safe for you all to do so. Before we begin on these conversations, are there any preliminary matters anybody wants to discuss?
Yes, Mr. Penny, can I ask a question?
Yes.
Chris.
Hey, Chris. Yes, sir.
I noticed on the agenda, the email I received, this meeting was 9 to 4. Initially, I didn't expect it to go that long, and I had scheduled another meeting, an important meeting, this afternoon. Is that, I'm trying to decide, do I need to cancel that other meeting and go from there? Do you have any idea of how long you're anticipating this to last?
9 to 4 was just a placeholder. I did not. I hope. Really, if both fingers crossed on my toes, that it doesn't go to 4 o'clock. So we can see where we're gauging after where we are after about 2 hours. I was speaking to Mr. Bellamy this morning, and the comparison I made is that goldfish will grow to the size of its environments basically, and I said this conversation will probably grow to the size of the time we give it. So 4 o'clock is more of a placeholder here at the PSC in terms of securing the area. I would like to finish it before then. Mr. Perry, what time is your meeting? What time would you have to leave?
It is at 1:30, and it is it's a national resolutions meeting for cooperatives all across the country. So I'm one of a handful of people that is participating in that. That's why I was asking.
Okay, so then what I might endeavor to do, rather than having a break for lunch, we may have a break, and then we'll go to about 1:30, and then we'll just break at 1, and then we'll end at 1:30, and we'll see what ground we can cover. I presume that the national resolution is not condemnation of me. If it is, then you have to stay. But other than that, I think I'm okay with it.
Fair enough.
Okay.
Thank you.
Thank you. Are there any other preliminary issues before we start? Okay. There being none, I'm going to turn it over to Mr. Bellamy, who is the drafter of the agenda, so we can kind of get through some of the hopefully there's a few things that we can resolve quickly, or at least move on from quickly until we get to some of the more substantive things. So, Mr. Bellamy, the floor is yours.
Yeah, before we get started, I was going to share my screen. Someone is sharing their screen. I don't know if they might not know they were doing that. I'm not sure who it is necessarily. But perhaps when I share my screen, that will go away, but someone's screen is being shared. And now I'll share my screen. Let's see. Are you all seeing my screen?
Yes.
Okay. It's not showing up on mine. I apologize. So the first topic that I put on the agenda, and I tried to cover the bigger topics that you all had kind of indicated you want to discuss, but then some of them just are just some little things I just had like a couple little questions about that I thought you might be able to clarify, and or where there might be some room, I guess, for agreement on things. But the first one was kind of a bigger one, I guess, and this was addressed in some of the initial comments of the attachers, and some of the poll owners, I think, sort of alluded to it in their responses, but there wasn't, a significant response. And it's basically, my question was kind of, with respect to the kind of the monthly rental rate, I feel like there is some obvious discussion of the cost with respect to the make-ready costs and things like that. And I know you'll have some disputes on that, but that is covered in the current reg. But with respect to the actual rental rate, I guess our position with the reg was kind of that, we're regulating it as a rate and requiring that a tariff be filed and requiring non-discriminatory rates, but it also brings in the statutory standard of fair, just, and reasonable, along with, other regulations pertaining to that and the commission's kind of body of case law pertaining to that, and that would be sufficient to cover the requirement in the federal preemption requirement that we regulate the rate, the attachment rate. And I know some of the attaching entities indicated that they felt like we needed to actually codify a formula within the reg. And I guess I was just trying to get, I think I know the attachers' position because it was in their comments, but there wasn't a whole lot of response to that. And I was curious, some of the poll owners and the attachers, obviously you can respond, what your all's position is with respect to the extent to which, and I'm not saying, taking a position like this is what it has to be, but best practice for the commission to ensure that there's no question regarding, our preemption, do you all think what we have is sufficient, or is there something that needs to be added, to kind of bring in the fair, just, and reasonable and the standards that we already have with respect to the poll attachment rate?
Well, this is Tip. I'll jump in. I think the electric co-ops agree with the view that you just expressed, assuming that's the PSC's view. The pushing of specific rate questions, which of course are fact-based, to tariffs and contract filings is consistent with PSC's past 4 years of practice or so, and in fact with current regulations. So we think it adequately preserves the commission's jurisdiction.
Yeah, and this is Eric Langley, speaking for Kentucky Power and LG&E KU. We agree with Tip on that. And I'll add to it because there actually is a great deal of specificity in the commission's existing regulations. I mean, Administrative Order 251 is actually pretty detailed, and in many ways more detailed than a lot of other formulas that may appear within rules. And so I think my recollection is that this issue was only raised by CTIA. I may be mistaken, but that's the only comments in which I remember it appearing. And I think that there's maybe too sharp a distinction being drawn between a rule-based formula and an order-based formula. And there are many other states that do exactly what Kentucky does, which is they have a separate order of general applicability that lays out in some level of detail how those recurring rental rates are calculated. So the short answer to the question, which is whether there needs to be a rule-based formula, is absolutely not.
And Mr. Bellamy, this is Dan Reinhardt with AT&T. AT&T was an additional commenter on this very topic. In our our initial comments, we provided a red line of the rule and suggested that a concrete reference to the FCC rules as modified from time to time and interpreted by courts and by the commission bureaus themselves, would be the most appropriate way to go with the rules that is being thought of by the commission here. If we go to this federal statute, 47 USC 224C, there are some specific requirements in there that go to this. Well,
Excuse me, I hate to interrupt, but can everybody please, if you're not speaking, mute your microphone? It's because I'm getting a little bit of feedback. Thank you.
Thank you. So 47 USC 224C talks about the requirement that a state have effective rules in order to have the fully reverse preempted. And the FCC in its codifying regulations at 47 CFR paragraph 1.1405 says that it would be rebuttably presumed that a state is not regulating attachments if the FCC doesn't receive certification from the state, and then it has a series of things. But one of the certification requirements from the FCC is that the state has issued and made effective rules and regulations implementing the state's regulatory authority over pole attachments, including a specific methodology for such regulation, which has been made publicly available in the state. Now, I understand with Mr. Langley's reference to the administrative ruling from 1982 as being readily available, public, et cetera. But I'd urge the commission to modernize the rules to reflect things that have changed very significantly since 1982, including the recognition of substantially more competition and the broader use of poles. In fact, the 1982 rule only contemplates either one additional attacher or two additional attachers on poles, and the FCC rules contemplate up to at least 4 additional attachers in its rules. So we urge the commission to follow AT&T's recommendation in our direct comments or our initial comments and adopt the FCC rules as the rules for defining the rates in the state. Thank you.
This is Allison with Duke Energy Kentucky. We would agree with what Mr. Langley and Mr. Depp just stated.
This is Matt Detour from CTIA on behalf of the wireless industry, and as Mr. Langley noted, we did raise this issue in our initial comments. We support AT&T and Mr. Reinhardt's position that the rules should be codified. The question on the agenda, I think, sort of lays it out, the extent to which the proposed regulation must address rates to preempt federal regulation. As Dan cited correctly, we've got 47 USC 224C on the books that sort of lays out this broad idea that a state has to regulate the rates, terms, and conditions of pole attachments. Obviously, everyone sitting on this call knows that we live in kind of this arcane little world of pole attachments here, and there have only been, I think it's 26 states that have reverse preempted at this point. So, if you're asking for a bright line answer on, is there applicable FCC declaratory rulings or case law or court law, the answer is not to the extent I can find. There, as far as I know, there hasn't been a challenge to what the rules and what you need to do as a state to meet 224C. But the reason we put that out there is that, as noted by Mr. Reinhardt, this is a rule that hasn't been updated since the 80s. So obviously a lot has changed both in Kentucky and at the FCC with regard to their treatment of pole attachments there. And I think, even as we try to figure out where the line is of what you have to do as a state to meet the requirements of 224C, I think it's reasonable to infer that a state should be providing at least as much clarity as the FCC for the sake of reverse preemption. And as you know, the FCC provides, a rate formula, clear dispute resolution practices, and over the past couple of years has taken further steps to codify its rules and to make clear for owners and attachers what the timelines are for attachment, what the timelines are for make ready, so that there's not this uncertainty going forward. And I think that the PSC has an opportunity here by codifying the rules, however it chooses to deal with rates, by ensuring that it's within the regulations and not within, a series of 30-year-old orders, that there's more clarity for both owners and attachers going forward with regard to the rates of rental.
Yeah, Ben, if the only issue is whether the formula laid out in Administrative Order 251 should somehow be codified in the rule, I don't know that that's controversial as a matter of practice. I don't think it's necessary to preserve the Commission's authority, which it's been exercising continuously since 1982. But I think that CTIA and AT&T are actually are raising a separate issue, and that is the actual merits of the formula at Administrative Order 251. And so it's important to keep those two issues separate. If the only question is whether the formula needs to be codified in the rule, the answer is no, it doesn't. But is there a strong opposition to that? Probably not. If there's a separate question, though, regarding whether that formula should change, which is an issue that would obviously require significantly more discussion, because if the formula is going to change, then I would suspect that many of the electric utilities have some suggestions that would change it in their favor as well.
This is Tip. I just want to jump in to reiterate, too, there's not any opposition, I think, to the idea of looking at the rate issues. I think from our view, if the Commission thinks that's appropriate, well, then let's get something on the calendar. The issue is, in the context of this proceeding, which, the Commission first clarified was to address access issues, this is a very, very hotly contested issue that gets deep into facts and experts and other considerations that this current proceeding really probably isn't well equipped to handle if the idea is to get regulations regarding access finalized anytime soon. Now, if we want to put cost, and that's where, frankly, I know I'm going to jump way ahead, but item 1 of Charter's proposed issues, I think this relates to it, because those make-ready costs as well are going to be contested in the same sort of way. It would seem to me that if the Commission wants to address those, that can and should be done separately. But again, to the specific point raised by the agenda item, it's adequate that the regulation currently refers to the tariffs, and then the Commission can, as it has in the past, use either administrative proceedings or individual rate-making proceedings to address those other issues.
Thank you. Does anyone else have a comment before we move on? Okay. The second one is a short one, I think. It's basically, I'll pull up this really quick. Basically referring to Kentucky Power's comment regarding kind of adding some information to the communication space, or to the definition of communication space. And I guess my only real question about this is, if you were to incorporate these like grade standards within the definition of communication space, is that a uniform standard that would be applied across all utilities, or would that grade standard be something that differs depending on the span and things like that? And if that's the case, would that be something that would be better addressed through a utilities tariff filing as opposed to including, a specific definition within the reg itself?
Ben, this is Eric. Since Kentucky Power is the one that proposed that. I guess I'll speak first. You're correct that the actual minimum grade clearance would vary from situation to situation, depending on whether it's a DOT road, depending on whether it crosses over an entrance to a property, and a variety of other factors. Terrain certainly is a part of that. And then in the hills, there can be significant variations. But that's why what Kentucky Power proposed was a pretty generic explanation of what that lower and upper bound was. We weren't purporting to define it in terms of feet and inches because it would be impossible to do that given the variability in circumstances. And so what Kentucky Power has proposed is actually very similar in substance to what is already part of LG&E KU's tariff. And it's actually a definition of the communication space that is pretty common in the industry.
And as far as the attachers go, did you all have any issue with this definition of communication space?
Yeah, hi, this is Jill from Charter. I don't really understand the need for this rule because the NESC defines the clearances, and as Eric was saying, they change depending on topography. Even the clearance between the secondary and the highest communications attachment can change depending on what's in the communication safety zone. It's very it changes all the time. And I feel like if there's something in here that says this is the communication space, and there's this defined space, and even though Make Ready could take care of changing that space, then that would lead to a lot of unnecessary Make Ready by unnecessarily defining these sections of the pole that are really just artificial and can be changed by Make Ready and are very static and changing all the time. And, we rely on codes to have those clearances, and this is a really unnecessary rule.
No, part of the point is a very good one, which is that the communication space can change. One of the reasons it's important to put this in now is because the rules more broadly include other remedies about what entities can do on certain parts of the pole to change them. And so that, I believe, is why the more complete definition becomes of greater relevance in this proceeding. It's because of the other rules that the Commission is proposing to adopt, including one-touch Make Ready and the self-help remedy. I would also note that what Kentucky Power has proposed is pretty much consistent with the way the NESC defines the communications space.
Well, I would say that in relation to the rules and the interplay between the rules, the FCC rules, other states that have adopted the FCC rules have the same issue with access to the communication space, OTMR, and don't find it necessary to have a static definition of what communication space is, because it does change. And I just feel like that I really am trying to understand the actual motive, and I really don't, except for the only thing I can think of is requiring an attacker to do unnecessary Make Ready and change out poles where it otherwise wouldn't be necessary.
Yeah, I don't understand what Jill was talking about there. The only motive is clarity and consistency with the NESC, given that the Commission is contemplating new remedies within the space defined as the communication space. That's it.
So, and you're saying that this definition is consistent with the NAC definition. So if you were following the NSC or the NESC, then it would say that, the communication lines can't be, X number of feet, within X number of feet of the electric lines, and then within X number of feet of the whatever grade it is under the specific situations. And
Yeah, the NESC is actually generic also, recognizing the point that I think everyone agrees on, which is that the precise contours change. The NESC definition, I think, the current one is the area below the communication workers' safety zone, the limit of allowable NESC clearance for the transportation or other governmental requirements and companies' internal construction standards on poles. Excuse me, that was incorrect. Let me read the NESC definition. The space on joint use structures where communications facilities are separated from the supply space by the communication worker safety zone.
And is the communication worker safety zone established by the utility, or is that something that's actually in the NSC? Or NESC?
It's in the NESC. This is Pam representing Kentucky Power. The other thing to keep in mind is the state regulations and the federal regulations on highways and different types of roads. Those regulations actually are more prescriptive on what the clearances can be. Certain highways require 18-foot clearance. I think there's some that are 15, and in some cases, if it's non-accessible by vehicles, it's 13 feet. So this definition is not getting that prescriptive. We're just saying we need to maintain those clearances as needed. And if the SAG, the mid-span is, say, 18 feet above grade level, at the pole, that may be at 21 feet. It just depends on the grade of the ground, where the pole is sitting. We're trying to meet those standards, and we want to be, as the pole owners, we're responsible for making sure that those clearances are met through our Make Ready.
But they're already incorporated in the code and or the law. The request here is to incorporate the required clearances, and so it would take pages and pages to include those. I guess I just don't understand the need for that. It's not in any other pole attachment rule. Everyone understands that Make Ready relies on what's in the code and in other laws, and that you can deny access if the proposed attachment doesn't meet those standards. So I'm just trying to understand the need to have all of the specific clearances where there's many set forth in the rules. You know, we can say something that we have to meet any, NESC and local standard that's clear, but I guess I still just don't understand the motive and the need for setting forth all the required clearances in these rules.
Yeah, maybe I can help the conversation along. That's not what Kentucky Power is proposing. Kentucky Power is proposing to add 11 words to the existing definition that after the word utility pole that says above minimum grade clearance and below the communication worker safety zone. That's all that Kentucky Power is advocating to add. We're not seeking to add pages and pages of variable specifications.
So Dan Reinhardt, this is Dan Reinhardt with AT&T, and in responding to Ms. Ellis and Mr. Langley, I've got a question for you. The suggestion that you have here would appear to absolutely preclude attaching ancillary equipment below the minimum grade level for cables. Is that your intent?
No.
Not at all.
Thank you.
I don't think so. This is Jeremy Gibson with Duke. Like Pam mentioned, she specifically pointed out mid-spans. I don't think ancillary equipment falls into that category. But Duke also agrees that pretty much along the lines with what Eric Langley was stating, just some clarity between the worker safety zone, putting that in there to know the difference between the communication space and the electric.
Is it your proposal to put a specific space or just these? And recognizing that the communication worker safety zone can change as well, depending on what's in it, like a grounded street light, like non-conductive fiber. And, I just want to make sure we preserve, what's the exceptions under the code to what the communication, what your perception of the communication worker safety zone is. And that's what's kind of concerning me.
No, yeah, it's, Jill, it's exactly the words that I had proposed. And maybe I was being presumptuous early on, thinking that people knew what Kentucky Power had proposed. I can see why the title might have led people, of the agenda item might have led people to believe we were advocating for something more. That is not. And so, Ben, to be clear, what Kentucky Power wants is only those 11 words that I said earlier, not if I knew how to share a screen, I could try to pull it up.
Yeah, I think I had the bulk of it here is incorporate no wireline attachments can lawfully be made below the minimum grade clearance.
No, that is not what we are proposing to include.
Okay.
It is just the phrase in the middle of proposed section 1.3 above minimum grade clearance and below the communication worker safety zone, which Jill has said correctly on a couple of occasions will vary depending on the circumstances, which is why we worded this in generic terms rather than with reference to specific clearances by feet and inches.
Well, perhaps if you reference the code and the code's definition of the communication worker safety zone versus, just sort of random utility standards, maybe we could get somewhere on that.
I think I understand. Did anyone else have any comments on this issue? Okay, I was going to move on to the number 3, which is right here. This was, and I honestly don't recall who made this comment now, but it's basically, there was a question of clarity within the reg. The reg establishes in section 4, A and B, as well as I think elsewhere in the reg, different deadlines based on where the communication or whether or not something is in the communication space or outside of the communication space. And I think, let me pull up the actual note here. So, and this is LG&E and Kentucky Power, and I think you were trying to basically clarify that that the deadlines are based on where the make-ready work is going to take place as opposed to where the actual attachment's going to be made with respect to the communication space or outside the communication space. Is that correct, Eric?
That's right.
And honestly, I guess one question I had is, do the attachers have any, I guess, issue with their requests on that point? Basically, just to add something to clarify within the reg, indicating, because I think right now it doesn't really specify what it's talking about, where the make ready, if it's the make ready or where the attachment.
Yeah, hi, this is Paul on behalf of Charter. We do have an issue with that, or at least some questions around it. First, we don't really understand what the objective of that change is. We were comfortable with the rule as it was drafted. But more importantly, it seems to depart from the FCC approach, which is pegged more to what kind of attachment it is than where it may go or what the required make ready would be. The FCC approach is really key to addressing unusual types of attachments, not typical work. And we worry a lot about departing from settled deadlines and well-reasoned approaches where we don't even know what the objective would be.
So I guess this question sort of has 2 points then, because I will be honest, when I was looking at the reg initially, my understanding of the FCC reg and the way it was incorporated here was that the deadlines were based on where the attachment would be made as opposed to where the make ready would be done. And I guess when you all pointed this out, the reg, like once it was, LG&E indicated that it was their interpretation, it was based on where the make ready was going to be done. I do think the reg is kind of unclear on whether the deadline applies to where the attachments are going to be made or where the make ready is going to be. So I guess there's kind of 2 parts to the question then. One is, do you include it in the reg? And then 2, like, do you specify in the reg, we're talking about where the attachments are made versus where the make ready is done? And then 2 is, which one do you base it on? And I guess the attacher's position would be that it is where the attachment's going to be made. And is that correct, Paul?
Right.
I'm sorry, Eric, did you have a response? I kind of interrupted you.
I really don't have anything to say that we haven't already said in our written comments. I mean, if there are going to be different deadlines for different parts of the poll, it seems like they would apply to the work being done rather than to where the attachment is being made, because under Paul's postulation, if there were a new wireline attachment that required lifting the neutral by 2 feet and raising the transformer by 2 feet, I mean, I think everyone would agree that that's subject to the 90-day deadline for supply space make ready, but the way that the reg technically reads, it would be subject to the deadline set forth for attachments in the communication space. That's not how anybody interprets it. So our proposal was really to align the actual language of the reg with its intent and the way it is applied. But the truth is, I mean, this is not a hill that anyone's going to die on, because I think it's more clear the way that we've proposed it, but I think everybody knows the way that this really works.
Okay. And you're saying with the FCC reg, they do base the deadlines based on where the make ready is going to take place as opposed to when where the actual attachment's being made?
Well, no, the way that the commission has proposed the rule is in fact consistent with the FCC. What we're saying, though, is that is a drafting error, and that the better way of expressing the way that this actually works is the way that Kentucky Power and LG&E KU have proposed it.
So you're saying in practice, everyone is going to understand that more time is going to be needed if you're going to be doing significant make ready outside the communication space, even though the attachment itself is within it.
I believe that's the case, but if the attaching entities in the meeting disagree, then I think that's important to hear and would certainly shed light on the importance of the revision we're proposing.
Yeah, it doesn't seem to me that there's a huge disagreement in terms of understanding, but the language of the rule as written does track the FCC approach. Everyone understands how the FCC approach works in practice. There's no confusion about that. And our concern is that if you amend it, change the wording, it may impact a change in approach, and it may end up with more delays, more complex make ready being done, everything shifted towards complex make ready, and ultimately slow broadband deployment and increase the cost of it. So at the end of the day, I agree with Eric. We're not looking for hills to die on here, but the current drafting is consistent with the FCC. No one's had any problems with the FCC approach. Everyone understands how it works and how it applies. And for that reason, there's no reason to muck it up with revisions here.
Thank you. I think I understand your positions. I appreciate it. This is another kind of small one. I think Duke had suggested this. It was whether to amend section 44A5 to allow the required notice to contain contact information for a department as opposed to a specific individual with information regarding the make-ready procedures. So it's when they send the notice out to the attachers and required to provide a contact. I guess, is there any disagreement among attachers that it would be acceptable for the utilities to provide essentially contact information for a specific department at which information can be obtained versus requiring that they actually provide a specific individual?
This is Jill from Charter. We were talking to our construction folks about this, and, what their concern is, the pole owners and attachers, talk all the time. And so there is a person that's typically responsible for this kind of thing. We have to provide our information to them when we submit an application. And I really, I feel like putting a name who you can contact for more information about make ready really shouldn't be that big a deal. That's how the rules are written in the vast majority of states. And I guess, what I'm worried about is that someone will try and call a department and it'll just, delay getting to the right person. I just don't understand the need. I just don't understand this request from Duke.
This is Allison Hunter, Duke Energy Kentucky. Our concern was, people leave the company, people get promoted, those different things could change from the time we provide that contact information to the time that they actually try to contact somebody. The department doesn't change. And so there would be somebody there that would be able to respond to that instead of it being an individual person that may, have left the company or been promoted to a different position or something like that.
Yeah, these notices would be someone contacting you in the next, 2 weeks. I just, again, not a hill to die on, but I just don't, understand that.
So this is Pam with Kentucky Power, and again, we didn't comment on this one or have anything to add other than to say we can support having a department. In our case, we have what we call a joint use mailbox that goes to several people so that if someone's on vacation, we feel that it's better to have a group of people as opposed to one person, because whether that department changes or not,
I've never seen anyone fight this rule, so just, it just seems unusual, so.
Joe, this is Jeremy with Duke. Can you give me an instance of what you're talking about? Like, you keep saying it'd be hard for somebody to find a specific individual within a department. Usually with the teams that are working on joint use are specific to joint use. And they're all familiar with the jobs that are in the queues and can easily look up and research and find these jobs. So I'm just kind of unsure why you feel that would be hard to get a hold of somebody if it's all centralized to one specific group within a company.
Well, it'd be easier to get a hold of someone with their name there. And if there are those individuals, they're just going to ignore the notice and just call who they normally call. So if you want them to call a specific person to discuss make ready, you should put the name there. If you don't, they're going to call whoever their contact is.
But again, if this work is within a specific group and different people are working different jobs, you might not have one point of contact even for all the jobs that are in the queue. So, it might need to go to somebody else, even though if you're calling a specific person, they might not have specific knowledge of the job that you're calling on. It might be somebody else, but it's all tied to a specific group. So it should be able to research pretty quickly. And if there is an inbox or a phone number that a question or something goes to, I would think that would actually be a smoother process, because if there's multiple people tied to it, they can look and see who has that specific job instead of passing it around within the group. Everybody sees it. If they have backups, as mentioned, went on vacation. I've seen that happen where companies have called engineers and requested updates and they're on vacation. And specifically, we might not have knowledge of that job and we got tracked down. So it's better to have a specific number to go to or an email box to go to so everybody can see it and know who is tied to that job specifically. If I'm making that clear, if you disagree, again, it's not one of those things we have to keep arguing, but I'm just trying to see if you understand where I'm coming from.
I think I understand both of your all's positions. And I mean, honestly, I can see benefits to both, to be completely honest with you, because there's times when one person might be on vacation, and if you only have one contact, then it might be hard to get them. But, and then perhaps there could be a situation where, if you don't have someone, maybe you did get the runaround. I don't know. But I do see both sides. So I think we'll kind of take this under consideration and then, go from there. The next one is kind of another small one, although I think there might have been some other comments on a related issue, but it's what's meant by AT&T, and I'll just pull up the actual proposed edit. So this was about, this was really just a question that I had. AT&T had proposed this, I don't know if you can see the red line there, but basically that application shouldn't be combined between simple and complex make-ready. When complex make-ready is required, the entirety of the project shall be subject to the more stringent standards. But I guess I had a couple questions about this. One was AT&T, what do you mean by the entirety of the project? Are you talking about every pole on the particular application? Or are you talking about any requests related at all to, there might be multiple requests even over a period of months that are on the same project. I didn't know what you all meant by that.
Mr. Bellamy, I'm waiting for Mr. Peters. I'm hopeful that he can respond. It'll be just a moment.
Okay. I did have another question. I don't know if anyone else can respond to this, but if you're submitting an application, you wouldn't, I mean, depending on the circumstances, but, you know, they're technically not required to do surveys before submitting an application. So arguably they wouldn't know what type of make ready was going to be necessary when they file the application itself. So they wouldn't know which polls are going to require simple and which are going to require complex. And I guess I'm curious how AT&T would expect that to work.
This is Jill. I think when you submit, when you're an OTMR and you want to do, you know, you're an OTMR attacher, you designate the make ready as simple or complex in your sort of pre-application.
Okay, I apologize. You're right.
Yeah.
I was thinking this was not, I didn't realize this was in the one touch make ready. So
Yeah. So yeah, I think, you know, I didn't really focus on this. I think it would be difficult for an attacher to separate them out like that. And I don't really understand. I mean, you would separate them anyway in your application. You would put in one OTMR and one regular. So I don't know if that's what AT&T is trying to get at. I mean, they would be two separate.
You would separate them, but I guess just back to the original question, and if you want to move, we can move on, and I can follow back up with you at the end if you want, AT&T.
I appreciate that, Mr. Bellamy. I think we've got a technical issue on this end, and we'll see if we can't get it solved.
Can you guys hear me now?
There we go, Mr. Peters.
Sorry about that. Yeah, I was speaking and obviously nobody heard me. You were right, Mr. Bellamy, at the beginning when you described it. You said really the intent of this is to make sure that the rules explicitly describe a situation where you do find complex make ready on an OTMR application, then that application would have to be canceled, and then the opportunity would be to file an OTMR application for those polls that would be subject to OTMR still, that have simple make ready, and then file a separate application for complex. Because logically, you can't combine the two because the processes are completely different. So that was really the intent. Project is probably the wrong term, and maybe application would be more appropriate.
Okay. Well, in that case, I'm ready to move on, unless anyone else has another question about this or comment.
This is Pam with Kentucky Power. I just want to clarify on those applications, if what the attacher proposes is two polls of simple, and the next poll is complex, and then the next three polls are simple, leapfrogging around like that makes it really hard to work. They're not going to be able to attach in spurts of two or three polls, jumping polls. So it still makes sense to look at the project. I mean, I agree that the way this is worded, it should be the entirety of the application. But in reality, it needs to be understood that it needs to be a whole line of polls. It shouldn't be pieces and parts in multiple applications.
Because if you have 300 polls on one basically straight line and one's complex, then none of the simple are going to go up anyway until the complex is done. So
exactly.
Yeah, that's kind of okay. I think I understand that issue. I don't know how you would define project though, I guess, because if you did it, a project could be really large or done in segments. So I don't know if anyone would have a better term, I guess, for that. But I'll just table that for now, unless anyone else has another comment.
Pam, this is Chairman Duke. You're saying you're against the application terminology?
No, I'm fine with the application terminology. I just want it understood in practice that if your application is two polls here, and then there's a complex for 3 or 4 polls, and then another application for simple 2 or 3 poles down, it all has to be worked together. It's not like they're going to attach application 1 and 3 while they wait for 2 to be worked.
Correct. And in that case, I think that's where I think seemed like everybody's agreeing that it would be, that would just have to go down the complex path and not specific piecemeal.
Agreed.
Thanks, man.
Okay. I think this was a suggestion by some of the attachers. Whether existing attachers, like the pole owners, should have the ability to object to attachments as complex pursuant to Section 10A3B when a new attacher is using one-touch make ready. So I think the current rule is that the pole owner can essentially reject anything as complex. And then it goes back to the normal process, I guess. And there was a suggestion by some of the attachers or the attaching entities that they be allowed to object to, which would then push a particular application or project to the normal make-ready procedures. I did have a couple of questions about that. I guess the one question I had was, I think with respect to the utilities, that under the reg, they basically have almost complete discretion to designate something as complex. And then if they designate it as complex, there's basically no appeal. They can't appeal to the commission. It just goes up to the normal procedures. And my understanding is the reason for that is because an appeal itself would actually take longer than the normal procedures. But the idea would be that if the utility is unreasonably designating, as a practice, poles as complex, then there would be a remedy for the attachers to file a complaint with the commission, basically indicating that the utility is acting contrary to their tariff or to the regulation. But there wouldn't be an ability to appeal specific designations of complex. And if attachers, particularly non-utility attachers, are allowed to designate attachments as complex, even if the utility doesn't, I guess my question would be, would there be any enforcement authority for the commission to prevent other attachers from making designations of complex when things aren't necessarily complex?
Yeah, this is Paul. Let me just speak to that and get to the reason why we propose that change the regulation. The real issue as we see it really is just striking the right balance between increased efficiency allowed by the OTMR approach while also preserving the integrity of the facilities of existing attachments. And from our experience and in light of our concerns, what we as existing attachers in many cases want is just the opportunity to ensure that there isn't going to be make ready performed that impacts our ability or puts in doubt our ability to continue to provide service. So we would like to have some say in that. Whether that requires a formal challenge or review process by the commission, I'm not sure, but that's where we're coming from with our proposed change.
Sorry, I was on mute. I'm not saying that attachers would necessarily do this, but I guess how would the commission enforce or prevent attachers, I guess, from unreasonably just designating things as complex when they might not otherwise be complex? And then also, like with respect to notice, would someone using, I guess I was just curious how it would work in practice also.
Sure, and the way I see this working in practice is really this is a discussion between the attachers And then the utility, of course, is going to weigh in. And our concern isn't with things being overly designated complex, it's that things are under designated as complex. So we'd like an opportunity to provide some input in that, but we think ultimately that's going to get worked out with the utility. I don't see in practice this being something that would require a whole lot of attention from the commission. I mean, these are ultimately business and construction issues that the utility is going to have an important say on. Our concern is just, as an initial matter, are things going to be under designated as complex and put at risk the continuity of our services? So I see these things being worked out informally through the OTMR process, not really with a back. Of course, the commission provides an important backstop, but I don't see this as something that's going to be escalated to the commission with any sort of regularity.
I guess that was kind of my point too, though, is that you can appeal under the current process. There's really if a utility designates something as complex, there's really no right to appeal it. It's just, you have to go to the slower procedure. And then, my reading of the reg is the only real right to appeal is if you thought that the utility was acting unreasonably, inappropriately designating things as complex as a practice, then they might be subject to penalty, but the application itself would still be subject to the slower procedure. And I guess that's the only enforcement, but arguably for some attachers, the commission wouldn't really have jurisdiction to actually impose a penalty against them if they were designating things as complex inappropriately, if they had that right to do so.
Right, and from Charter's perspective, we look at this from both sides, right? We're an existing attacher, but we're also going to be a new attacher in rural areas that we intend to build out. So it's not as if we're trying to take some kind of approach that's going to slow things down, because we intend to take advantage of OTMR when we can. It's just a matter of, again, as I said at the outset, just striking the right balance between increased efficiency and making sure that any new construction isn't going to disrupt the services of existing attachers.
Ben, this is Eric. From the electric utility perspective, we're speaking specifically for LG&E, KU, and Kentucky Power. I mean, what they would be looking for in a one-touch make-ready application would be to ensure that there was nothing about the pole that would actually require make-ready in the supply space. And so the electric utility typically is not going to be evaluating whether the surveyor's designation of make-ready within the communication space has been inaccurately denominated as simple. And I think that's Paul's point, that Charter, if it's the existing attacher whose make-ready has been designated as simple, but actually involves a complicated splice, then Charter may want the opportunity, even though the utility has not, to designate that make-ready as complex. Paul, am I understanding your point correctly?
Eric, we may not agree on a lot, but we agree on that.
I understand why you all would want it, because utility's not looking. I guess I was just trying to think about how it would work in practice and things like that. But I do appreciate your all's comments.
And this is Allison Honor, Duke Energy Kentucky. When we received this agenda and we talked about that with the company representatives, they just wanted to make it clear that Duke Energy Kentucky would have the final say over the electric work, that the attachers could not, have any say over the actual electric work that may need to be done.
Okay. Thank you.
Hey, Mr. Bellamy.
Oh, yeah, go ahead.
This is Jill. I think we skipped one. Item 5 about the prepayment for pre-construction surveys.
Oh, I apologize.
That's okay.
Well, we'll go back to that one right now then.
Okay.
So this basically, I think there was a suggestion that we delete the provision in section 4.2(b)(6)(a) that allows, it doesn't require, but it allows pole owners to require prepayment even for the survey work. as opposed, I think, and I can pull up that section. I think that was something that was added that's not in the FCC reg, but I think it was added because I think the FCC reg anticipates that the survey work is going to be paid for, but I think at times maybe it's not entirely clear, and I think this was also added for larger projects to kind of ease concerns, particularly for smaller utility or co-ops that, they might not, they can hire contractors so that they would have the funds available, I guess, to hire contractors to actually process the surveys if necessary. But I guess I'd be interested to hear y'all's comments on, what the utility's position is on that, removing that, whether it matters. Because even if it were removed, you would still be paid for the survey work. You could just send the bill out with the estimate for the make-ready work, I think is how it would potentially work.
Ben, hey, this is Jeremy too, whoever's caller 13, I think that noise is coming from there. Can they mute, please?
Did anyone have any comment on this particular proposal?
I do, but I thought you wanted to hear from the utilities first.
Well, you can go ahead if.
Yeah, I think we spoke about this briefly last time. Most of the IOUs require us to do the pre-construction survey right now. And in their tariffs, there's reimbursement for pre-construction surveys. What concerns me about the upfront payment is that it provides for another step that delays the process. So, we would submit our application and then they would have to come up with an estimate or something at some point. And then we'd have to cut a check and get that paid before they even undertook the survey. That's kind of what concerns me most. I think, for the most part, the reimbursements have worked and, if we're not paying bills, that's a larger issue. But I think having that pre-construction survey at the actual costs, with the make-ready estimate, I think that's the best solution. Otherwise, the process can get very delayed.
Sure. And I'm excited that comment. I didn't know did anyone else have any comment on that?
Yes, thanks. This is Tip. I guess I'll speak up. I mean, the way the reg is drafted 6A, first of all, it doesn't require prepayment. It allows a utility to require that, but also talks about some other reasonable security or assurance of creditworthiness. So essentially what it does is gives the utility flexibility to deal with that if it's not, reasonable for it to go ahead and essentially front those surveys. I think the viewpoint from at least the cooperative perspective probably is they're not especially interested in essentially being the bank for the communications companies who wouldn't want to prepay. And moreover, if there were any delay, cooperatives don't know the communications companies' capital deployment plans, for example. They know that. So they can plan for that and they can be prepared to have checks ready if indeed, a request for prepayment is actually made. And I don't have the data on how often that happens, but the regulation proposed has other alternatives and seems reasonable.
How's the attacher going to know what the cost is unless you give them an estimate?
Well, it won't know the exact amount, but it should have. It's got the benefit of experience all over the country on surveys. I think it probably has a reasonable estimate. And I'm not, we can all, I suppose, be afraid of issues that could come up. You guys are just like everyone else is. Everyone's afraid of that. I don't think that's a significant issue, and it seems reasonable to leave that to the discretion of the commission as to whether and how it approves what's in the tariffs of the utilities.
Yeah, Ben, I suppose one way to balance the concerns here would be to say that if there's going to be prepayment, then perhaps there's a published estimate of the per pole survey fee. I mean, that's actually pretty common in other jurisdictions. I don't know that it is in Kentucky, but a lot of individual utilities will have a handbook or a price sheet or something that'll say that the fee that includes the application processing and the pre-attachment survey or $100 or $150, whatever the cost is. And so that money could actually be submitted with the application. So that's one way of solving the problem that Jill has raised, which is a fair one, that it is another step in the process. For Kentucky Power and LG&E, it's not a huge issue. Right now, Kentucky Power bills it after the fact, but it would like the opportunity to later seek to include it in the tariff if it thought necessary. And of course, as we discussed on the last meeting, LG&E KU actually requires the survey to be submitted as part of the application. So it's sort of a moot issue for them right now. But I think that the rule that the commission has proposed is a good one, and it strikes the right balance.
Thank you for that comment, Eric. When you were mentioning like that they include an estimate, what is the typical, say for if someone were to submit an application with 300 poles in it, what would be the typical, and I know it's going to vary, so I'm not really trying to tie you down, but what kind of costs are people typically requesting for that type of survey work? If you know.
Eric, you want me to take that one?
Yeah, Pam, if you would, that would be great.
So typically, because we use outside contractors to do our engineering in most cases, we have a unit cost for that. And it's going to depend on the type of project it is. If it's all complex, if there's some okay to attach, whatever, we basically tell attachers that they can figure on average $250 a pole for their application for the engineering.
Okay, thank you. I was curious just how much money was involved for one, but then also, if there is a specific number, you could, as Eric said, include it with it, and if they pay that, then it could be trued up when the actual bill goes out later, just like the other estimate costs.
That's kind of what we were suggesting, that if we go with this, we would want the ability to, for say a large project, if there was a chance that an attacher is slow to pay or whatever, we would want the ability to take that estimate up front, and then we'd have a true up at the end.
Because if it's 3,000 poles, then it could be, that's at 250, that's $750,000 about. Yes.
And that's the engineering. So that's the engineering on top of the pre-construction survey, on top of an application fee. What I would say, well,
for us, that's all of it. That's the entire package of, if you give us an application for 100 poles, it includes the application fee, the contractor doing the survey work and doing the work orders. So that's how we got that average, was based on if I had a 50 pole proposal that was all okay to attach, if I had a 50 that was just rearrangement and a 50 that was complex, that's where we got that number.
Yeah, okay.
But not actually completing the make ready work, Pam, is that correct?
That's just the engineering. It is not the construction piece of make ready.
Okay. Thank you very much.
And that's not how everybody does that, but so there, just so you know, a lot of the upfront stuff is pretty random and never gets trued up. So that's also part of the problem when you have a flat fee, that it's a flat fee and it's never trued up.
One last addition.
Jill, thank you.
Last addition on that, Ben. I don't think what's proposed here is really different than what currently exists under, for example, at least in the case of me.
Yeah.
Dan,
Ben,
this is Al. Oh, sorry, Chris, go ahead.
well, I was just going to say, and there are attachers in different parts of the state that may even be smaller and getting into different business structures and stuff. Some of those don't have the credit worthiness of almost every company that is on here, and we have had instances where a company said just wanting to see what was happening and get an estimate, and then they never go through with the project, and then we're kind of stuck. So we think that is an appropriate provision, especially for some attachers that are not as sophisticated or as credit worthy as those that I see on this call right here. Sorry, Allison.
That's okay, Chris. This is Allison Honaker for Duke Energy Kentucky. Correct me if I'm wrong, Jeremy, but currently Duke Energy does not require the prepayment, but we would want to reserve that right in the future, like the utilities have said, if there is an instance where we think that may need to be required.
You beat me to the punch. Yes, that is correct. We are very similar to what AEP does. I don't have exact figures, Ben, at this time in front of me, but it's a very similar process we bill after the fact, but we would like to reserve that right.
Thank you all. I think I understand all your comments. And thank you for pointing out I skipped that. Sorry about that. I think this was a suggestion. I'll just highlight the one that I'm on so I won't forget it. But whether existing attachers should have 30 days to complete make ready before new attachers utilize OTMR process. And I believe this was, I know it was one of the electric utilities, I think, suggested this. And I guess I did have one question. I guess my question on that was, with 30 days to complete, would that not or would that not eliminate, I guess, some of the benefits of the One Touch Make Ready?
Yeah, this was a suggestion that Charter actually made, and it's really for the same reasons as we discussed in Section 7. The idea is that it's a balance between efficiency and protecting the integrity of plant. We'd like the opportunity to get out there and, consistent with the OTMR timelines, make the changes that we need to make before triggering any opportunity for a new attacher to make them. So we don't see this as slowing down the process. We see it as consistent with the process while also ensuring the integrity of the attachments for existing attachers. And, as Eric had said, and I agree with, we would like the opportunity to perform whatever work on our facilities needs to be done first.
So in practice, with that work, they would submit the surveys and applications to the utility, and then you would receive notice, and then from the notice period, you'd have 13 days to move your attachments. Is that what you're suggesting?
Yeah, 30 days.
Okay. Any other comments on this? Thank you. This had to do with, I think AT&T suggested being able to use their union contractors for make-ready work. And so I guess the agenda point that I put was just whether AT&T or similarly situated utility should be permitted to use its own workforce for make-ready pursuant to a union contract, and when that permission should apply. The questions that I had, and this is, I guess, for AT&T, it wasn't exactly clear to me from your comments when you would suggest that your union workforce would be used. Are you talking about when all make-ready is done on AT&T poles, like AT&T's workforce should be used to do all make-ready even for other attachers? Or are you talking about should AT&T be able to do its own make-ready with respect to its equipment on its poles? Or are you talking about when AT&T is attaching to other people's poles that its contractor should be able to do all of the make ready on other people's poles when it's the attacher or the applicant?
Yeah, Dan Reinhardt here. I'll defer to Mark Peters if he can get back in. In the absence of Mark being able to speak, our view is that our collective bargaining agreements require that any work on our cables be done by our workforce, and that's what we're seeking here. Will be AT&T should be able to do the make ready on its own facilities, on its poles, as well as on utility poles.
Okay. And I think I understood everyone's arguments for and against this in writing. I think it was addressed pretty heavily, but if anyone has any other comments, feel free to weigh in.
Ben, this is Jeremy Gibson with Duke Energy. Just want to verify this is limited to the communication space and not the electric make ready. Is that correct?
That would be our intent, yes.
Okay, thank you.
And can I ask Dan a question? This is Jill from Charter. Dan, I'm just trying to understand, because in the context of the FCC rulemaking, rulemaking in New York, where those arguments with regard to collective bargaining agreements were rejected, they were rejected because the phone companies wanted to use their workers to do surveys and make ready even when the deadlines were missed, and even for one-touch make ready. So I guess that's my question, just so we all understand what the context is. If you miss the deadlines, are you suggesting that no one be able to seek self-help?
Yeah, that is a difficult question, Jill. Clearly our intent would be to meet the deadlines.
Okay, but the argument is that you would like to use your contractors even if you don't.
I think that's implicit in this. Clearly our intent would be to meet deadlines. I'm sorry, it's not a better answer.
Okay, I just wanted to make sure that was the answer. But thank you for your honesty there.
Thank you. Did anyone else have anything else to say on that point before we move on? Okay. Thank you all. This was kind of a two-part, and these were kind of related, but it basically had to do with the ability to impose additional standards in Section 5 with respect to contractors. So it's whether Section 5 should and would, as written, permit a utility to impose additional standards for approving contractors authorized to perform self-help for attachers in their tariffs or on a case-by-case basis. And then I think there was the other suggestion of whether any construction standards that exceed the NESC should be demonstrably necessary for specific safety reasons that cannot otherwise be achieved by following NSC or other generally applicable and applied. So one is the extent to which you can go beyond and add additional standards, and then the other is I guess the standard that would be applied for adding additional standards. And I guess the question that I had, my reading of Section 5 is that it would allow utilities to impose additional standards, both in their tariff, definitely in their tariff, and then potentially on a case-by-case basis. And I guess I did have some thoughts or some questions. For the poll owners, do you think as written, does Section 5 currently allow additional standards within the tariff, and does it also allow things that might not be in the tariff that might arise based on the facts of a particular application that you would be able to impose additional safety standard in that case?
Ben, this is Eric Langley. I think that Section 5 of the proposed rules is really limited specifically to the issue of standards for contractors, which I believe is a separate issue than whether there could be distribution construction standards that exceed the NESC. On the first question as to whether the rule as drafted would allow the pole owner to impose additional requirements than those set forth in the proposed rule, I think the answer is yes, but I also think that Duke, who made this comment, has identified a legitimate ambiguity. So I'll let them speak to that issue with more clarity. It would certainly be Kentucky Power and LG&E KU's position that they should be able to impose standards other than the minimum standards set forth in proposed Rule 5 for what constitutes an approved contractor under the rules. But Jeremy, do you want to address that further?
Yes, thanks, Eric. This is Jeremy Gibson with Duke Energy. So our reasoning behind this is wanting to go above NESC is several things, but most importantly, safety, number one. Two is the reliability of our system that need to be considered. So safety, reliability, best practices are the reasons we want to be more stringent than what NESC requires. The last thing we need is somebody getting hurt or our facilities getting taken out for not being fully qualified to work on our facilities.
Yeah, Ben, this is Chris. I just want to make the point that some of the engineering requirements that we may have as part of our covenants with the Rural Utility Service may go above and beyond the NESC requirements. And we certainly want to reserve that right if we have a contractor that's going to be doing some work, that they would build that to the specifications that we may outline pertaining to keeping people safe and reliability of our system based on some of our standards. So at times we do exceed some NESC standards for maybe clearances, locations on poles, a number of different factors that are pertain particularly to engineering construction standards for us.
And the one thing, and this is Tip, the one thing I might add to that too is it seems pretty self-evident that the proposed regulation kind of goes out its way to prescribe some general reasonableness considerations and also preserve to the commission the discretion to make sure utilities are not unreasonably withholding consent. Sorry, yes.
And Ben, this is Allison Honecker for Duke Energy Kentucky. I went back to look at our comment on the summary. I think we were taking maybe some objection to the words any contractor in there and just making sure that we were still able to kind of go through that process and our review of each contractor before we added them.
Okay, thank you.
Paul, I think we were talking about two separate issues here.
Yeah, I wanted to weigh in. I just didn't know if now was the right time. So there are two separate issues. One's addressed in Section 5 and one's addressed in Section 6. With respect to the contractor issue that's addressed in Section 5, our objection to the imposition of additional requirements for other contractors is really twofold. One, in the main, we rely on the utility's own contractors. And two, the FCC has addressed this and found that it's sufficient to have minimum qualifications for contractors. There's no need for additional standards for other contractors, and it seems a way to either deter or delay the building of broadband facilities, and totally unnecessary, as the FCC has found. With the issue in Section 6, we certainly recognize that there may be situations or circumstances where standards need to go above and beyond the NESC, but utilities' ability to impose and adopt and apply those standards needs to be subject to certain safeguards. And we've adopted some additional language to ensure that any additional standards are reasonable, non-discriminatory, and adopted on a prospective basis. And this is particularly important to Charter because we have real experience with utilities in this area and on this call where we agree on certain standards, they're adopted in a tariff, and then they are subject to different changes, increased standards, and other variances through informal documents like construction manuals and workbooks. And what we want to ensure is that, yes, while we recognize that there may need to be application of different standards in some circumstances, that those standards are known and fair and appropriate and adopted through proper procedures.
On the point of the standards, and I apologize for kind of mixing those two issues. I know the contractor, I thought one of the contract requirements was that you could require them to follow the specific standards. But with respect to the standards themselves, how does it work in a situation where you would have prescribed standards, but obviously you can't anticipate every single situation that might arise on a particular issue? I mean, if there's something that arises, when a survey's done and there's someone determines that there's an additional need for some work that might not be specifically laid out in a standard, would there be any ability for a utility to require that under the proposal that you were making with respect to requiring the standards be laid out and done in a non-descriptive and in a prospective basis only?
Well, yes, our language really tries to balance the need for change, but also the concerns that we've raised. And so we've laid out language in C and D that we think accommodates those. But of course, the issue really is with standards that are adopted. We understand that there may be situations, exigent or otherwise, that require special situations or considerations. But what we want is that when utilities sit down to adopt standards, that they do them in reasonable and non-arbitrary ways. And so we think that needs to be set out and codified in the rules, given our experience with certain utilities practices.
And just to give a real world example of something that happens a lot, and this is mostly for unregulated entities, there was the communication worker safety zone that we were speaking of before, and it's typically 40 inches below the lowest electric line and the highest communications attachment. We've been, not a few times, several times, been given a demand that now that clearance has to be 70 inches. And clearly that's not a safety issue. That's an issue of someone wanting usually us to have to change out poles when make ready is necessary because there's never going to be a 70-inch clearance. So things like that happen, and we just want to make sure that Anything that does exceed the NESC or a lawful requirement like the RUS is adopted for particular safety reasons that are necessary and not prescribed on a going backwards basis.
Dan, I think the commission has jurisdiction to determine whether a standard adopted by an electric utility for reasons other than safety, like reliability or engineering, is reasonable. And if the utility has adopted a standard that is on its face unreasonable or is as applied unreasonable, then an agreed detaching entity would have a remedy. But there's never been a requirement anywhere that I'm aware of, and certainly it is not the FCC requirement that utility standards be capped at whatever the NESC says. To the contrary, there have been numerous overtures over the years by attaching entities to try to adopt a rule that makes the NESC somehow the limitation on electric distribution and construction standards, and those efforts have been roundly rejected because local conditions are going to require different types of standards, and no single set of universal standards can accurately capture all of the variables. Moreover, the NESC itself, it isn't a design code, and that's not just a subjective evaluation. The NESC says this is not a design code. So yes, there are going to be standards that the co-ops have, that the investor-owned electric utilities have, that are going to exceed the NESC. And from what I can tell, and Ben, you have a better handle on this than me, the Kentucky Public Service Commission seems to treat the NESC as a minimum standard, not as a normative or a maximum standard.
Well, and just to respond to that, we recognize that, and we're not looking to enshrine the NESC as the end-all be-all for standards. Well, all that we're asking, and as we identify in the proposed language, that any additional standards above the NESC that a utility seeks to adopt are done for appropriate reasons and in appropriate ways. It's a more a process point than anything.
And I think, at least from the cooperative perspective, everybody could agree that any restrictions like that would be adopted for reasonable and proper purposes. And at the end of the day, system integrity and safety is the responsibility of the pole owner and the electric utility. And when someone, we're going to assume, I don't think we need to have an unreasonable fear of the boogeyman, assume that operations are done for reasonable reasons. And just like attachers have had the right for years to come in and raise complaints if indeed this were happening, it would continue to have that under the proposed regulation. And so I think, in addition to that point and aside from it, just to go back to the point Chris raised earlier, I would think as the commission, you would want to be very careful not to accidentally create a scenario where credit facilities and things of that nature may be endangered, accidentally put into a breach scenario as a result of some regulation.
I think I understand everybody's point. I did have a question, Tip. What did you mean about, are you saying that because there might be a condition in a credit agreement that requires certain conditions to be followed, that if, with respect to the use of equipment, that putting something that didn't allow the utility to follow that would, put them in breach of those agreements?
Yeah, what I was, and I don't have detailed knowledge of, for example, the RUS credit facilities that Chris mentioned, but to the extent those facilities impose requirements that go beyond NESC requirements, if the commission were to do something that, as a result of this regulation, then required folks to come in, you would have created a breach prior to that as a result of the enactment of it. And so it seems that really we kind of got our priority backwards. Let's let the person responsible for system integrity impose the requirements, and then if somebody thinks that those are unreasonable, they can come and show that.
Okay.
And Mr. Bellamy, this is John LaFollette with LG&E and KU. We agree with what Tip just said 100%. our biggest concern here is that somebody other than LG&E and KU's own standards group or engineering group would be in a position to determine what is appropriate for our facilities. We're in the position of maintaining safe and reliable electric distribution systems, and to have one of our customers dictate the terms of how we maintain those facilities and under what standard we do that is just not a reasonable position.
Yeah, and to be clear, I think you all need to take a look at our proposed language because it doesn't purport to do any of that. It doesn't purport to tell the utilities what standards they can set. It provides more safeguard around how standards are adopted and what principles they need to follow and adhere to. And I think everyone on this call recognizes that the standards that get adopted can't be non-discriminatory and arbitrary. And those are the types of things that we ask be specified in the regulations with our amendments.
Paul, would the fact that the reg already includes requirements that essentially that the tariff include non-discriminatory rates, and let's see, basically there's an inclusion of the non-discriminatory requirement, and then there's also the inclusion of you have to provide access to the poles, but you can deny access for safety, engineering, other purposes. Would the application of those two standards effectively cover the proposal, or I guess why wouldn't the application of those two standards cover what you're proposing here, which is adding kind of another layer with respect to the construction standards?
Well, they wouldn't for the practical considerations that I mentioned and Jill amplified, that we recognize that there are situations and occasions where certain standards need to be changed and need to be set out with more specific detail through construction manuals, and that we need to ensure that those practices too are safeguarded against abusive or arbitrary or unreasonable conduct. So we made some changes to the rule to which you're referring, but we don't think that goes far enough when it gets to the actual construction and design and implementation of the requirements.
So in essence, you're asking utilities to have every standard that is adjusted pre-approved.
Is that what you're talking? Are you talking to me?
I'm talking to Paul. I'm sorry.
Okay.
That's not all what we're asking for. And I think if you review our proposed amendments, you'd see that's not what we're requesting at all.
Yeah, Ben, this is
John.
At the same time,
Go ahead,
let me just finish my thought, because at the same time, there's been several suggestions that, well, the utilities can just adopt whatever standards they want, and then if the attachers have a problem with them, then they can just come to the commission. That is not a workable approach for attachers who are looking to deploy facilities and serve customers on a reasonable time frame. What we would like set out is just clear rules of the road when it comes to changes. We're not dictating what changes are okay or are not okay. We're not asking for pre-approval, but we ask that the commission set some clear rules for the road for how changes and design manuals and the like are carried out by the utilities up front, so we don't have to litigate the matter.
Ben, this is Eric Langley. If we're just talking about what KBCA proposed, then our objections are much more specific, because actually we expressed in the comments, Kentucky Power and LG&E KU expressed in their comments that probably 50 to 75% of the additional language that KBCA had proposed in Section 6 was acceptable. There were a couple of tweaks that we proposed, but we did not object to the notion that any standards adopted or revised needed to be reasonable, non-discriminatory, and applied on a prospective basis. So if that's what KBCA is still seeking, then that is something that LG&E, KU, and Kentucky Power can accept. And we've laid out the specific revisions that we think need to be made in order to adopt KBCA's proposal in our written comments. I actually thought we were talking about a more generic issue about the practical limitations on what those standards can be.
No, and just to be clear, we're only talking about the language that we proposed. That's it.
Okay, any other comments on this? Okay,
Mr. Bellamy, can you hear me? This is John Tyler with AT&T. Mr. Bellamy, can you hear me?
Yes, I can hear you now.
Okay, great. I've had a very difficult time with audio and not, as a result, had an opportunity to chime in on some of the issues that AT&T was being asked to address directly. So it may be that after this call, we have something more robust to add in writing, if that is permissible or required. But thankfully, I'm now at least able to speak.
Well, I'll have to talk to Jeb about that. Maybe we can have a break and then Jeb can get back with you about that, after the
That's
break.
fine. And it may
Or
run out.
I can give you, we can give you an opportunity. If there was something you wanted to comment on, I'm assuming it was on the, let's see.
It was on
the itch
number,
with respect to.
I'm sorry, it was number 9, but then also just in general to either speak to AT&T's agreement or disagreement with positions that have been espoused by some of the other parties. But I certainly don't want to hijack the call, and it may not at all be necessary. I think that Dan has sufficiently addressed those issues at this point, and to the extent that they have not been fully addressed, and we will take that back up with Jeb offline. Thank you.
Okay. Jeb, would now be a good time for a break, or if we're going to go to about 1:30? It looks like we're pretty much halfway through, if not more.
Yeah, I was thinking that maybe we could take a break to about 11:15 and then resume and maybe try to finish up by 1:15 or so at the latest. Is any objections to that? All right. There being none, why don't we see you all back here in about 21 minutes or so. Thank you. see if we're, hopefully everybody's back on. I really don't have a way to check if everybody's back on that was on before, but I do have a question. Mr. Tyler, are you on the line right now?
I am. Can you hear me?
Yes. And so your question was,
Great.
Your question was about, circling back and possibly making comments on some of the sections that, you may have missed. And I'll tell you this, I don't want any more comments filed because it's just going to open up everybody filing additional comments on this. So if you have anything to say, if you want to say it now on some of the topics, I would appreciate you doing so.
Okay. And this was, I think, item 9 regarding AT&T and similarly situated companies that may have a unionized workforce. And what we were asking for is that our union contract be acknowledged, and the fact that our bargain for workforce in the first instance be allowed to do one-touch make-ready on AT&T's facilities, not on facilities of other carriers. And I think there may have been some confusion. I hope not. I think Mr. Reinhardt explained that well, but I just wanted to make certain that that was understood.
Thank you.
Thank you.
Just to clarify, and I apologize, my sound was actually not completely working for the first couple seconds, but are you, I understood what Mr. Reinhardt said, but are you saying that AT&T's contractors should be able to do the make ready on their facilities on other people's poles?
Yes.
Okay. Thank you.
You're welcome. Thanks.
If no one had anything else, I was just going to go back to the agenda to item number 11, which is, I think it was LG&E and KU maybe that suggested that we revise it and add some language accounting for the issue where attachers fail or refuse to move their equipment after receiving notice that a new pole's been installed. And, oh, go ahead.
Well, no, sorry, Ben. I thought you were finished and asking us to talk. Let me let you finish, though.
No, go ahead. That's fine.
It was actually LG&E, KU, Kentucky Power, and I think that the co-ops proposed something similar as well. It is just enshrining a transfer rule that would enable electric utilities to help solve the double wood problem, which is a very real problem out in the field. We actually were able to, I say we, LG&E KU was able to get some data about the scope of the issue to help put some numbers on this. For example, in KU territory, there are currently 9,000 double wood situations. We don't have data on the pending transfer tickets there, but we do have data for LG&E territory, and there are 3,500 double wood situations, and the average age of the next to go ticket for transfers is over 2 years old. So these things really do languish in the field for a long time, and there may be lots of reasons why that is the case, but the limited rule that is being proposed here by LG&E, KU, Kentucky Power, and the similar rule proposed by the co-ops would be a step forward in the ability to help remediate that situation out in the
Yeah, this is Chris Perry. This is a serious problem in rural areas. I'm surprised, Mr. Langley, that number wasn't as high. I was driving from Harrodsburg to Danville just recently on the KU system, and I counted a number of poles. Of course, that's one of the more rural territories, but that is a great source of frustration for cooperatives across the state. We certainly believe that that needs to be addressed, and we'd like to see that. That is, I get calls from everybody, from a farmer to even a state legislator will call me wanting help with moving these. Now we've sent the request in. I need to make sure we're doing it. I wish I had some data and I'd looked it up, but it is a real problem.
This is Jill from Charter. We have no issue with this provision. This is in almost every pole attachment agreement we have, and so we have no issue.
Thank you.
This Jeremy Gibson with Duke. We're okay with it as long as it allows rather than mandates. But we'd also, as a poll owner, we'd like the commission to have some sort of remedy against the communication companies in here, not just tie it specifically to the poll owner.
What do you mean by that?
Well, the commission have some sort of leverage or language to streamline these transfers. I mean, as Eric points out, this is a very real issue. We've seen things all over across the board from, we got to wait for the next guy to transfer and to that's an O&M cost and we're not doing it. So, while it gives us the remedy, we feel that the commission should put some language in there as well around that to kind of push this issue along. I don't know specifically off the top of my head, but it's definitely that's something that needs to be addressed because, as stated, there are customer complaints. There are complaints from legislators. I've had some specifically. We get complaints from all sorts of customers as well, again, as we've been threatened from certain municipalities to hold permits to do any type of work until these are cleaned up. So it is definitely a big concern among the public.
Thank you.
And this is John McCullough with LG&E and KU.
So wait first. Go ahead.
Yeah, thank you. This is John LaFollette with LG&E and KU. I agree with everything that Jeremy and Chris have said regarding Doublewood. Obviously, it's a clutter in the right of way. Aesthetically for communities, it's not desirable. But it's also it is and can become a safety issue. Having an old pole there. There's a reason that the pole was replaced, and frequently it's because it's at the end of its useful life and is no longer sturdy enough to remain supporting facilities. And so having that old pole there does present safety issues. And something that we've encountered with our operations folks is even if LG&E or KU has the remedy of performing that transfer for the communications company and thus being able to pull the old pole. Even if it's that expense is fully reimbursable, we run the risk of becoming the communications company's transfer contractor for all intents and purposes. And so having some kind of incentive, or I guess disincentive, built into the regulation to kind of encourage the communications companies to perform these transfers in a timely manner, I think would also help remedy the problem.
This is Jeremy with Duke again. I agree with what was just said. That's why we're okay with it allowing rather than mandates. I mean, if it becomes a mandate, communication companies are just going to utilize us as a contractor to do all their transfers. So that's why we're recommending the commission have some sort of leverage on this one as well.
And this is Jill. We don't want the electric utilities to become our contractors. We'd rather move our stuff. Sometimes we don't get proper notice. There's a whole bunch of issues. So I feel like, before we kind of go somewhere where that hasn't been raised in this proceeding at all, that, there might be another workshop on double poles or something like that, because I feel like, there's a lot of information coming from the utilities and they're asking for something that's new here. We're fine with this rule. We try to do transfers in a timely manner. Sometimes we get a lot of transfers all at once that aren't expected. Sometimes we go out and the person above us hasn't moved. There's a whole bunch of reasons. And so, before these attacks continue, I'd just like to say that, if we're going to do something like that, I think we need to do it in a different forum.
I understand that. And I know with Duke and LG&E, you all kind of suggested something, but I mean, you don't really have any specifics to put on the table that anyone could respond to.
We don't want to speak for the commission on what kind of language they should put in specifically. We kind of just feel the commission should kind of review that from their perspective and see if there's any leverage they can put in the language to address this themselves, along with the remedy that's there in the language.
And I guess I can ask any of the attorneys that are on here. I mean, with respect to the remedies against attachers, I mean, other than potentially imposing a remedy through, with respect to their ability to continue attaching or their rates, I mean, would the commission necessarily, depending on the attacher, have any jurisdiction even to oppose a penalty against an attacher?
But
assuming it's not a telephone utility.
Commission's regulating attachments, and it were to impose a mandate that attachers move their facilities within X period of time, and to compensate, if they didn't, then to compensate the utility who had to do it in their stead. The attacher would still have violated the regulation. I would think the commission may have some authority under 990 to address that, in addition to recompensing the utility who had to pay the cost of moving.
As a person who violated the regulation, basically.
Yes.
Thank you. With respect to and I understand there seems to be broad agreement, at least with the language that's proposed, not considering adding any kind of penalty or anything like that. But I did have a question. Kentucky Broadband and Cable Association had some suggestions if this were to be approved. And I think they suggested if the procedure was adopted, that the deadline should be sized up for larger projects. Notice should be required and allow for deviations for situations beyond control. And then they also suggested that the attacher whose facilities are transferred should receive the same notice, inspection, and cure protections proposed for One Touch Make Ready. So I think 15 days after making the transfer, and then 90 days to inspect, and then 14 days following the inspection to report on any damage or code violation. I was just curious what the pole owner's position was on Kentucky Broadband and Cable Association suggestions with respect to adding that, assuming that the Doublewood proposed language was accepted. Because I think they did that in a reply, so no one had a chance to respond to it, really.
This is Pam with Kentucky Power. I guess I'm struggling with that because had they done their transfers to start with, we wouldn't have to be transferring for them. I don't have a problem with us notifying them that the transfers are being done, but they got the notice that they need to transfer. So I'm really struggling with the need for that piece.
I think some of it does deal with actually the notice and the time period. I think extending the time period for larger projects. I'm assuming if you're doing a significant number of poles in a particular area, I guess scaling up the time periods. I don't think there was actually a suggestion as to what the time period would be, but and then deviations for situations beyond their control. I think that might be implied in the reg already, but perhaps, it could be cleaned up to allow something.
So based on the LG&E KU data, where they've got some next to go tickets that are 200 or 2 years old, that seems extreme. And I don't have that level of detail for Kentucky Power, but what kind of timeline would you need? Would you need it extended to? I guess 2 years is ridiculous.
Yeah, I think the reg is LG&E and KU and Kentucky Power. Your all's proposal is 60 days. Is that correct?
Yes, that's correct. Absent some different provision within a tariff.
Sure. What would your all's position be on with respect to larger projects and extending the dates? I'm assuming as long as it's a reasonable time period, you wouldn't necessarily have an objection to it.
That's right. Speaking for LG&E and KU, I don't think that we would be out there ready to perform the transfer on day 61. There's going to be some obviously some reasonableness built into this, as there always is, and we're more concerned about the scope of the current issue and the huge delays in getting these transfers performed. If we submit a large number of transfer requests all at once, as in the hypothetical that you suggested, of course we would be flexible and understanding of the need for the attachers to find resources to perform those transfers.
Is that common? I mean, how often do you submit? Like, what's a typical submission that you'll submit to them to transfer?
I think the most common are one-offs. We don't do that many. Pole after pole after pole in a series needs to be replaced. Most typical, like I said, are the single pole requests.
So if you were replacing like a significant number of poles at one time, would you basically have the attachers contractors come almost out there with you all, like moving their equipment almost at the same time as you all go along, like replacing a series of poles?
I can't speak to that question. Go ahead, Jimmy. Yeah.
I was going to say, this is Jeremy with Duke. It depends on the job, really, and the speed that it needs to be done. If it's a road widening job that's governmental driven, obviously there's going to be some timeframes that are implemented on everyone. So something like that, yeah, the comms are going to be right behind us and getting it done in a lot faster period than a single pole that might be out in the middle of nowhere. So, those are the ones that are sitting probably the longest, probably well beyond 2 years, as Pam mentioned, in some of these rural areas. But, it really just depends on the job end.
Okay. That's what I was wondering if the double, because they're talking about scaling it, but I was wondering if the double wood issue is really an issue more of the one-off poles that no one wants to drive out and fix, as opposed to the situations where you're doing a major like pole replacement project and they'll just come right behind. Because I've seen the double woods, but I've never seen like an entire row of them.
I have. This Jeremy, sorry. Yeah, this Jeremy. I have. They do exist. So, but it is a mixed bag again, and it really depends on the time frames and who's pushing the job, who's driving it, whether or not it's going to get done faster or not.
This is Pam again. Back to the thought of the electric utility, the pole owner being the contractor for the attachers. I can tell you from a Kentucky Power perspective, we don't like to have to do those transfers. We don't want to have to do those transfers because we're not trained in touching fiber and touching cable. And our folks, for the most part, are leery of doing anything more than a very simple move a bolt transfer, just because if there's any damage to the attachers' facilities, the liability that's going to come back on us. So we would much rather see them move their facilities.
Thank you. Any other comments on this particular topic? Okay, the next one was just the implementation of the regulation. I know there was a lot of comments on this, so honestly, I can kind of refer to your all's written comments, but I mean, there was kind of a broad range. I kind of just wanted to get a discussion about, because there's a lot of issues with implementation. There's the implementation with respect to the, special contracts, which could be carved out, and then there's the implementation with respect to existing tariffs, and how that would work. And I guess I just kind of wanted to get, it seems like there would need to be some, obviously, implementation period. And what kind of period that would be, and whether or not the reg should go into place to the extent that, allowing the tariffs to remain in place for a certain amount of time, but the reg goes into place to the extent that it doesn't conflict with the tariffs, particularly with respect to the access issues. And then how long should utilities have to actually update their tariffs to bring it completely in compliance with, the current reg? And I guess I was just trying to get people's thoughts on the best way to move forward with that, with actually implementing the reg, and then what kind of, carve outs with respect to special contracts and things like that should be within the implementation of the reg. And would anyone like to start that discussion?
Well, Ben, I'll start. This is Eric Langley, because Kentucky Power actually did propose a rule that would touch on this in Section 3, and it was essentially a rule that would make a rate term or condition within an existing tariff presumptively reasonable. And we talked about this a little bit, I believe, in the first session. I mean, the tariffs are not unilaterally imposed. They are submitted to the commission. Stakeholders have an opportunity for input. The common course is that there is input, there is negotiation of certain terms, then there's an updated submittal proposed for commission approval, and then it's approved, and then it becomes the tariff. So I guess the fundamental point there is that from the perspective of LG&E, KU, and Kentucky Power, if it's already in an existing tariff, it is just and reasonable. And so there shouldn't be any kind of subsequent recrimination or reversal of the provisions in that tariff. But that's really the only issue that we raised specifically with respect to how the rule would be implemented. Certainly, if the tariff doesn't address an issue and it is addressed in the reg, I think that we would agree that the reg controls. But where a tariff specifically addresses an issue in a different way, we think that revision or that provision should control.
Mr. Bellamy, go ahead.
Well, I guess I was going to ask, because LG&E is in somewhat of a different position. LG&E and KU and then some of the investor-owns have varying, I guess, complexity with respect to their tariffs. I know LG&E and KU at least has a really complex that kind of implements a lot of some of the similar stuff that's in the reg, but then with some changes to that. And I guess with the proposal that the tariff itself would be presumptively reasonable, would that be until LG&E next proposes to amend its tariff, or would you, if there's something that's already in the reg that or in the tariff, that it would be basically allowed to stay in there indefinitely until there's some change?
think it would be the second of the two, although I hesitate to agree with indefinitely because that presumes something that might go on forever, which I don't know would be the case. But hypothetically, if LG, and you're correct, LG and EKU have more detailed tariffs than any of the other investor-owns, at least in Kentucky. And so if they went in for a tariff revision in the next rate case, the position that they don't want to be in is having to undo all of the things that have been included within the tariff in the preceding revisions that have already been vetted by the parties and approved by the commission.
And I understand that. And I guess one point, to the regulation would be to add some uniformity with respect to the attachment procedures. And I know LG&E's I know the tariff attachment procedures are different, although when you all do the high volume contracts and stuff, oftentimes it ends up being implemented in a very similar way to the tariff or to the reg as proposed. But, let's assume, I don't know what the commission would decide on this issue, honestly, so I can't really speak for them, like if they want to allow the tariffs to continue control, but I know the idea is that there would be some uniformity with respect to at least the access provisions, with utilities having control with respect to the rates and construction standards and stuff like that. But assuming that the commission they don't want to have the tariff out there that conflicts directly, because LG&E does cover these issues. Some of the tariffs out there may not even cover some of the access issues, so there might not even be any conflict between them. But assuming that the commission didn't want a tariff out there that directly conflicted with the reg with respect to the access, but also don't want to force everyone to immediately file a case, particularly when certain utilities file cases on a fairly regular basis anyway, what would be a reasonable period, I guess, to allow provisions that conflict with the regulation to remain in place before a proposed tariff has to be implemented to actually implement a tariff that actually conforms with the regulation, I guess?
So, Mr. Bellamy, Dan Reinhardt with AT&T. In our opening comments and red line of the rule, we suggested in Section 9 in a new subsection, or Section 4, subsection 9, that the existing tariffs would be conformed to the requirements of the new regulations within a year. The idea here is, and you've hit on this in part, there's really two aspects to the rules that are under consideration. And some of it is the one-touch make ready and the methods and procedures and timing that go with that. Some of those terms and conditions may or may not be in individual carriers' tariffs, so the regulation could simply govern. But as we have proposed elsewhere in our write-up, we suggested that the commission expressly adopt FCC rules as to the rates. And to the extent that a different rule would come into play that would supersede administrative practice or the administrative regulation 251, we're suggesting a 1 year time for a 1 year time for conformance to the new rule.
Okay, thank you.
KB, yeah, if I can chime in, KVCA agrees that existing tariffs need to be conformed to the regulations promulgated by the commission. Otherwise, as Eric said, new attachers may never have the benefit of the new regulations to the extent that existing tariffs remain in place. Attachers don't control when utilities put in new tariffs, and if the existing tariffs are allowed to remain in place, then attachers may never have the benefit of the regulations at a time when this commission is seeking to promote broadband deployment. In terms of timing of when they are conformed, we think a year is probably too long. There needs to be some transition period, but I know AT&T suggested a year. We think that may be too long. We don't think that these changes are so substantial or significant that a year changeover period is really required.
But you acknowledge that some changeover period would be required, I guess.
Right. We're not trying to be unreasonable. We understand that there needs to be some time period to allow conformity. We just want that to be an expedited period, given that there aren't substantial changes in critical respects, and that the existing tariffs can be conformed to the new regulations.
And there is a kind of a related issue, because some of the utilities, I guess, have in place more in-depth pole attachment tariffs, whereas others might just have, one that's not as in-depth, and honestly might not necessarily even anticipate some of the things in the reg, because the reg has proposed, if you're just talking about the access provisions themselves, like in section 4, it has the time limits in there, and it anticipates that the utilities would include essentially their terms and conditions of access either within a tariff or within a license agreement that's attached to or reference to a tariff, but it does anticipate that the utilities would have the ability to require a license agreement to be signed. But, I know with LG&E and KU, at least they have some sort of license agreement with terms that are actually different, than are in the reg, but there might be other utilities that don't have any license agreement readily available in their tariff. And if we impose the reg, and even if it was automatically applicable to the extent it didn't conflict with the tariff, would they then be required to comply with the access provisions without having the ability to require someone to sign a licensing agreement that actually has all the terms and conditions that they want to impose as part of the connection?
Well, we're not saying that license agreements aren't required. The issue is, as you said at the beginning, the commission is working to ensure greater consistency, uniformity, and clarity around access rules. And to do that, the existing tariffs need to be conformed with the regulations, and new regulations or new tariffs or new agreements need to be set forth consistently with that. So yes, we think that utilities who don't have or don't address many of these issues can and should adopt them through tariffs and individual license agreements. And many attachers have those agreements with KU and LG&E. Our basic point is that while we understand it may take some time to implement it and ensure clear rules and consistent rules and uniform rules, we all need to do that as quickly and efficiently as possible, recognizing that it may take some time and existing tariffs will need to be changed. But we don't want, what we are worried about is a situation where the commission adopts new rules that in critical respects don't have any real force or impact because of existing tariffs that may carry on forever, which would defeat purposes of uniformity and consistency and clarity, all geared towards promoting broadband deployment.
This is Tip. I've been kind of hanging back a bit because I wasn't sure how to answer your question without another question. And I suppose what I'm hearing from everybody is it depends what's in the reg. And particularly with respect to some of these issues about make-ready costs and attachment rates. I mean, if the commission were giving any thought to that, I think it's going to take an extraordinarily long amount of time. But if, as the process started, we're focused on access-related provisions, I mean, we've got roughly 20 electric cooperatives in the state that have their own counsel and need time to, review and understand what's in there and get things addressed. But I think that could be done in a quicker time frame for sure than something broader.
That's kind of what I was wondering. Like, there's the access provisions, which there is obviously some cost provisions in there. And arguably they could, the deadlines and stuff could be imposed pretty quickly, but the problems might arise in that if the tariffs don't have the licensing agreements or terms and conditions that are kind of anticipated for attachment in them, then, they might put any utility that doesn't have that kind of information already in their tariff in a position where they have to actually develop that before it can actually be implemented. So.
And Ben, this is Jill from Charter. Our agreements with, I think, LU and KGE are merely 3-pagers that say we're going to follow the tariffs. I don't see, why they can't be revised to say that the parties are going to, follow these particular rules. The pole attachment agreements in Kentucky with the investor-owned utilities are just different than in many other states where you have, a comprehensive agreement. These are pretty, they just say you're going to comply, the parties are going to comply with this or that. So I don't see why that would be very difficult for people to adopt quickly with regard to the access timeframes in particular.
No, I don't think that would work, because there are many things that will not be in the reg, but that are a part of the tariff that don't conflict. And so an example of that would be the insurance provision and the indemnity provision in LG&E's and KU's tariff. Those things are not addressed in the reg. They are addressed in the tariff. So to the extent the regs are going to supersede the tariff in some respects, it would require a revision of the tariff to reflect those, because the tariff covers 60 things, the reg may only address 30.
But if we already have an agreement that we have to comply with the tariff, and the tariff doesn't include any of the access timeframes, then there's no conflict. So I don't know what you mean. If we can just revise the short license agreements that we have to include the new rules, I don't see how that's going to be difficult, or why that should take a lot of time.
Yeah, I don't know what to say other than what I just did.
Yeah, any other comments on this topic?
This is John LaFollette with LG&E and KU. Jill, I agree with you to the extent that revisions to agreements are necessary. The paperwork aspect of that can be done pretty quickly. But as Tip said, it kind of depends, it largely depends, I should say, on what the regulation ultimately looks like in terms of what operational changes are going to be necessary from the utilities perspective in order to comply operationally with the substance of the regulation, not just the way that it's expressed in agreements with the attachment customers.
I understand that there has to be an implementation period.
I want to direct this is Chris. I'll kind of direct this back to you, Ben, and maybe even some staff that may be available there, because 19 distribution co-ops, we need to do some work on our tariffs. We're reviewing them right now. We're doing some work on that. We'll be coming to the commission with these changes as well. I'd like to kind of push that back. What kind of capacity and timeframes do you have to review that many tariff filings that may have unique circumstances for across differing utilities?
Yeah, and I don't have the answer to that question, but I was thinking of that question. That was kind of what I was talking. I was kind of referencing that, and obviously, if every single PO owning utility filed a tariff within 1 month, that would probably strain the resources, would be my guess. But, so that was kind of, one thing that I was thinking about. I don't have the answer to that off the top of my head, but, that's definitely something I think that will be considered, when we look at like the implementation.
Right.
So yeah, we'll definitely consider that, and also, the implementation periods that you all need as well.
I think
Which, I think that, and I was kind of looking too at like, and I guess it takes a lot of thought, what parts maybe could be implemented, and what parts couldn't, and maybe, it might be hard to separate everything. But yeah, that is a good point though.
Right, and Mr. Perry, I think part of it would be driven is what proposed effective date you have on the tariffs that hit the door. Because the commission would have a certain amount of time at which they could suspend it for an investigation, but they're still under a statutory deadline to get an order out within a certain period of time. I wasn't around for the Admin 251 hearing, but as I recall, if you look at the case filings, there were several months of utilities submitting tariffs to conform with the administrative case, and those tariffs getting pushed back and forth between staff and the utilities. I imagine that hopefully with electronic communication, we can have maybe some discussions before some of those tariffs hit the door. But we shall see. Obviously, I mean, like everybody else, we would always like to have more people here to do the work of the commission. But once again, regardless, we would be held to a certain type of deadline just by statute.
If nobody had anything else, I was going to move on, just to make sure we can kind of get to the things people want to talk about. And I might just ask just briefly about this. This basically expected cost. No one really mentioned expected costs of the reg or anything like that. And I know this is kind of a big topic. I was just curious if anyone had any thoughts on whether the extent to which this would likely increase costs, keep them the same, or decrease costs. And on the point of, I did have some thought with respect to the actual, when you're talking about the cost of pole owners with respect to survey costs, the make ready. The reg anticipates that those will be paid by the attachers, assuming that everything works out properly. But if, and I know there's some disputes about new poles and stuff like that, so I'm not trying to reference that, but I guess would pole owners anticipate that this would significantly increase their costs, the regulation as proposed, or is it just changing the timelines on work that would need to be done anyway, and then would be paid for by the attachers?
This is Tip. I'll raise two issues that implicate the answer to that. One of them is what we're going to talk about on point 14 and staffing questions. The other one is this, we've raised this in our comments before, the notion of post make ready inspections. And when a utility pole owner goes out in the field and inspects work that was done and finds there was a problem, I believe the originally proposed regulations did not include the FCC provisions that allowed for the utility to recoup the expense of getting that fixed or to make that fixed. So that's a hole, and if the hole isn't filled, I think it imposes potentially significant costs to utilities. Again, coming back to the idea that these are our systems; they got to be safe, and we can't have problems sitting out there unrectified. So what we would like to see is a provision in here, even from the FCC regulations, that authorize those post-attachment inspections and a pathway for the utility to be made whole and for the problem to be fixed.
Well, and Ben, I'm sorry to interrupt if you were going to speak, but Mr. Depp, our question is twofold. One, we wanted the information which you have stated that of expected costs, but also two, there is a proposed bill in the House of Representatives here in the General Assembly that for, at least on our side of things, when we're going to try to promulgate this regulation, it will amend the standards regulations that require us to make a statement whether or not, and this is assuming the bill becomes law, whether or not that the regulation would have a quote-unquote major economic impact on the regulated entities, and that's defined as an annual impact of $500,000 or more. And if that's the case, then with the proposed legislation, the regulation actually has to be codified by the legislature in a statute. So that's the other part of our asking that question. I just wanted to give a little background when we're looking at cost. It was twofold. One, are there going to be additional costs to it? But two, would those actually be able to be quantified? That's more of a practical concern for us when if the bill is passed as it's proposed. I can't remember if it's House Bill 144 or House Bill 3 or Senate Bill 2. It's one of those three. One of them is the kill Judge Shepard bill to get things out of Franklin Circuit Court. That's not the one I'm talking about. There are two that have some restrictions on, I think, emergency regulations, but also with that major economic impact language in there. Just something to consider. I think that it's one of those three bills that I just cited. So anyway, carry on, Ben.
Thanks, I appreciate that. I wasn't aware of that.
Yeah.
So basically, the concern would be staffing, and then the post attach inspections, which I think there was some proposed language on that. I guess, did anyone else have any comment from a poll owner perspective on that issue of potential costs? Okay. As far as, did any attachers have any comments on their thoughts on whether or not this would increase costs to poll owners or? Okay. Well, then I will move on to number 14.
And sorry, it's House Bill 144 is what I was referring to for those that are keeping score at home. Sorry.
So that, I don't know if anyone had the opportunity to kind of get some information on this, but basically I was just trying to get a sense of, there is the deadlines in the regulation are kind of set based on, how many attachments, how many poll requests are being made. And I guess we were trying to get a sense of both what the capacity of the attachers is and what the capacity of the poll owners is, so that one, we're not requiring poll owners to be ready to process attachment applications that are in excess of what attachers are even likely to make in Kentucky. And then two, and then also get a sense of what kind of capacity poll owners even could develop, so that we're not imposing on the poll owners something that they couldn't even satisfy. And so I guess I was just going to start, if anyone had any comment on either what the typical or the maximum capacity of an attacher would typically be on a major project to actually make attachments in Kentucky, kind of like on a pole by pole basis, or how many miles they can typically attach in a given period of time. And then if anyone had any information on the actual rate at which historically attachers have attached to poles. And I'll just leave that open to anyone who wants to weigh in.
Hi, Ben. This is Jill from Charter. We talked to our construction teams about this, and they had done a big project in Indiana last year. And once all the make ready was done, their rate of deployment was fast, 5 to 10 miles per week. And that's like an average 100 to 200 poles per week. So they can go pretty fast once everything's done.
That's 100 to 200 poles per week.
Yep. Yep, 5 to 10 miles per week.
This is Chris with the co-ops. I'm sorry, Jill. Were you gonna say something else? I'm so sorry. I thought you were gonna say.
I was just gonna say that was like the average they gave in a rural kind of area.
Thank you for that information, Jill.
Yeah, we've never really seen that. The Kentucky Wired projects were the biggest we've handled, which were 300 to 400 poles for some co-ops over about a year. So this is that scale is significant, and the question you just asked, Ben, on cost, that could be significant for us. We, I think I might have heard John say it a second ago about their team, or maybe Jeremy. We don't have a significant team ready for pole attachments at our local electric cooperatives. That's just not the case. So, we would have to staff up dramatically. It would be contract employees. And, I would hope you would understand the time frames. When with the 300 to 3,000 poles that I see in this regulation are significant to us. And we've never seen that. I was looking through the past year or two on some of our co-ops. I asked this data. 30 poles was about as big as we would get at a time. So that is a magnitude larger, a couple magnitudes larger that you're talking about. So that is very significant. What we can handle internally regularly, and we do it, is 50, 75 poles internally. But anything getting above that, we are going to be using outside resources, and that's what I hope is understood here. That those time frames certainly will have to take that into account, and we would really like to propose, if that's going to happen, Jill, that Charter come meet with us all the time, so we know what's going on. Unfortunately, we haven't had as good of communications at times with communications and attachers as we need to. But if that's going to happen, we're ready to meet and get scaled up. That's when we don't want to have to come to the commission about. We can do it, but it's just going to require a lot of very well thought out communications. Now that's on the rural cooperative side.
Yeah, of course, and I think that's another kind of issue that will be explored. And just to clarify, this is after Make Ready's done, that we can deploy that quickly. So I think that
basically after Make Ready's done.
Yeah.
Yeah, and Ben, this is Eric Langley speaking. LG&E and KU are in a slightly different situation because their tariff for several years has actually specifically included a process and a protocol for higher volume deployments, which I think under the current version of the tariff are defined as in excess of 300 in any 30-day period. And so that requires the execution of a high volume deployment contract. And two entities have actually entered into those agreements with LG&E and or KU. Incidentally, none of the entities on this meeting today have sought or executed such an agreement, but I believe it's MCI Communications, which is a wireline division of Verizon, and Metronet that have executed those agreements with LG&E and KU. And so I'm going to turn it over to John LaFollette to talk a bit about how the actual deployment corresponded to the large capacity volume that those attaching entities were seeking.
Thank you, Eric. So to start with the MCI Verizon Wireline entity, they approached LG&E in 2018 about a 12,000 pole attachment project that they had anticipated would take about 2 years. And so in the 2 years that we did negotiate a high volume agreement with them, as Eric said, and filed that with the commission. The terms and conditions are available on the commission's website, obviously. So they had proposed 12,000 attachments in a 2-year period. And since we executed that agreement, LG&E has approved 2,891 poles, and Verizon is attached to 1,709 out of the 12,000 that they had expected or planned on attaching to. About 2,500 additional poles were ultimately, they were submitted by Verizon and then canceled. So probably about half the project, it looks like, 2,900 versus 2,500. 2,500 had been canceled by the applicant. So a very small fraction of the anticipated volume of attachments had even been sought, and then an even smaller fraction of that have actually been attached. Similar story, but not quite as extreme with Metronet. They had proposed, and we agreed to review and permit 40,000 poles in 2 years. We reached a high volume agreement. This agreement was between Kentucky Utilities and Metronet. And of that 40,000 in the 2-year period, they have received approval for about 14,000, and they're attached to about 8,000 poles. Kind of similar to Verizon, there were about 5,800 poles that they had submitted applications for, but ultimately canceled for whatever reason. So the poles per month figure, based on the length of the project and the number of poles that ultimately received approval for attachment. For Metronet, it's about 220. For Verizon Wireline, it's about 107. And to Chris's point about Kentucky Wired, we also have some data on that project. That's obviously been going on for a lot longer. We didn't have an anticipated volume of attachments from them from the beginning of the project, but we wound up approving about 16,000 poles. They're attached to about 15,000 of those currently, and that works out to about 250 poles per month. So each one of these high volume, probably the highest volume projects that we've encountered since we've had the option for a high volume in our pole attachments tariff. Each of those has been under the 300 pole per month limit that we have, or criteria, I should say, that we have for even being high volume to begin with. So as far as attachers' capacity on these higher volume projects, these numbers speak to historically what has been the case. Obviously, we can't predict the future, and business plans may change. But as Eric said, we haven't had high volume requests from any of the representatives from the attachers on this call, and from the high volume projects that we're familiar with. They just don't reach the expected or anticipated number of poles within the number of the amount of time, I should say, that the project is described as lasting.
John, just a quick follow-up.
Sure.
You talked about the number of attachments for like the Metronet and the Verizon. And I'm assuming there might have been months where, they're winding up or winding down. Do you have any number, like what was the highest month on any of those projects?
I do, but not handy. I'd be happy to pull those for you, Ben. And it's true that there was I do remember there was kind of a winding up period like you described. But both of those projects are still ongoing. They're not finished. And we're just not seeing the high levels that we were prepared for and that they had asked for.
John, this is Pam. Can I ask you a question? On the polls that were canceled by the applicant, had you performed engineering on those prior to the polls being canceled?
Well, I think it's probably a mix of yes and no. I don't have specifics. I know that on some of them we definitely had. I can't say that all of them we had performed engineering work on those, but some of them we definitely had.
And I don't have the level of detail you do on the projects. I just know, especially in the Kentucky Wired project within Kentucky Power, we ran into a lot of rework. We would get large volumes of attachment requests, and once we would do the engineering and provide the make ready, then it would be, oh no, we don't want those poles, and they would change the route. So it's not just the size of the project coming at you and the time frame, it's making a decision prior to applying. Don't use us to do the engineering, because you're wasting our resources if you're not going to take that route. And along the lines of, we're going to have to hire contractors to do the engineering as well as the make ready. But from the engineering aspect, if I have to bring in contractors, I can't just bring somebody in off the street. I'm going to reach out to my resources. I'm going to ask for contractors. It's going to take them 60 to 90 days to hire somebody, ramp up training, and be able to hit the ground and start doing engineering work. So we just ask that if you're going to come to us with a large project, if you can give us as much notice as possible. We don't want to get into anti-competitive. We're not going to go spill all your secrets, but if you can give us a warning of what's coming far enough in advance that we can start getting those resources lined up, we can work together much easier.
And that's one of the part C, honestly, and we can kind of just, if you all want to address it as you go, is sort of like, if there is a larger project, what would be a reasonable time frame? Assuming there was a requirement that they provide notice if they want to use like a high volume project, what kind of time frame? And I know it could depend on what the actual number is, but if you're talking about what you think you can get to as your kind of maximum kind of reasonable high capacity, what kind of notice would the utilities kind of be looking at to get so that they can get the staffing in place to actually process these kind of higher volume applications? Because it sounds like they are, from the attachers last time we spoke, it sounds like that kind of happens a little bit now, and maybe it happens better with some attachers than others. But I'm assuming if you're doing a very, very large, tens or hundreds of millions of dollar project, I'm assuming you've been planning that for some time. It doesn't just happen overnight. So providing some notice shouldn't be too hard, but I'm curious what kind of notice utilities think they might need.
Mr. Chairman, Duke, the longer the better. We've had similar scenarios with our attachers here. One was already mentioned where we jumped up our normal guideline a little bit. We limited to 500 poles per calendar month per attacher. So you got to think, if you got 5 or 6 attachers coming in same time and they're all permitting 500 poles a month, you're now looking at 2,500 to 3,000 poles per month. That's worst case scenario, but I've seen it happen. So it doesn't happen every year, but getting the resources in and not being told ahead of time can be really, really detrimental to the utility, because we're not going to meet our time frames. And then the next thing you know, we're getting complaints at the commission or wherever the case may be, that we're not hitting our time frames yet. We haven't got made notice ahead of time. That's happened with 2 large attachers. We've had good and bad. So the one company we're working with right now, they gave us, I think they gave us about 3 months advance notice of a 30,000, 10,000 per pole, 10,000 poles per year job. We would have liked a little bit longer for that. But to kind of add on to what Pam was saying, we're getting these applications in with this specific company. We're approving them with make-ready issues or whatever the case may be, and they're adjusting their entire routes, which then requires re-engineering and everything else, and it just adds to the time frames. And so it's not necessarily that we're not meeting them. We could be hitting them, and then the next thing you know, turn around and the whole route's redone. So another issue we've had with attachers on these big routes is they'll want to permit a significant amount in the very beginning. And what they'll do is they'll get the approvals back and they'll just sit on them and not build out until they have the entirety of the project ready to go. So, we've got certain timeframes because you might have another attacher that comes behind them. So we might have certain timeframes that need to be met for them to build out, and they're not meeting them. But yet you got another attacher coming right behind them that wants that same pole space. So you kind of gotta be cautious of who's attaching and when, and when they hold up the permits that you've given them, it can make things pretty hard from an engineering perspective.
Well, if they don't pay the make ready costs within 14 days, I mean, you'd be able to pull it. Are people paying the make ready costs and then sitting on it?
Yes.
Okay.
And then for all of those reasons, and especially given the history of these high volume or purportedly high volume deployments that John raised, we think that the solution that Kentucky Power and LG&E KU have proposed on this is a good one, which is that for deployments that are going to or anticipated to involve more than 300 attachments in a 30-day period, that there be a negotiation, a good faith negotiation that addresses all of these variable concerns. And like Jeremy said, there's a difference in terms of the type of notice that is necessary for an efficient project management between 400 polls a month and 4,000 polls a month. And so that would be the type of detail that should be handled in the high volume deployment plans. And I think that the revisions we proposed fairly and squarely address that issue.
Sure. I definitely understand your all's position on that. I was curious, just because of time, does anyone have any more thoughts on just the capacity, what attachers have historically done as far as deployments in Kentucky? I think most people have weighed in. I didn't think it was. And then the second part of that was, and this is probably a little bit of a tougher question because I know a lot of you are using contractors, but for the high volume, but what kind of capacity do utilities think that they could actually hit? And this goes for the co-ops too. Assuming that you're given the time that you need to obtain contractors and staff up as necessary so that you're not having to maintain staff the entire time. Is there a number that you think, you could hit, or, I guess if you can hire as many contractors as you want, the sky would technically be the limit, but I was curious what you all thought.
This is
I guess,
great.
yeah, what the utilities and the attachers think would be a reasonable number that you actually could hit, for a high volume project after you've had time to actually staff up.
Yeah, this is Chris. I'm going to hesitate to give a number because we haven't seen that yet. But I am going to ask Sean Knowles here in just a second. He works with us and he consults with cooperatives across the country on these things. Sean, how much could and how long would it take us to get? Because staffing limitations on contractors in our areas can be difficult as well. I'm going to be honest with you. Finding line workers right now to contract with us is not an easy proposition to do this work. But Sean, you may have some experience across the country. Would you be able to offer anything on that? I'm sorry, can you put you on spot like that?
Ben, can you hear me okay?
Yes.
Yes, I can. Thank you.
Okay. Yeah, I just wanted to kind of tie together a couple things that Chris and Tip have both been alluding to, which is that, I think to create capacity for the co-ops, there have to be some initial staffing at the base level just to have somebody on hand, and a lot of co-ops just to process these, just to interact with attachments and process these requests, which in a lot of cases doesn't exist. So there'd be that sort of base level need for staffing. And then, the other issue is the communication. We did a sort of informal poll of some of the co-ops, and not scientific, but the respondents that we got said that fewer than half of their attachers had submitted a request within the past year. And so, some level of communication has to be established. And, I would suggest like a quarterly meeting so you can have a plan, so you can understand, the forecast, what's coming. And those are the kind of sort of baseline things that would need to be done to create capacity. For co-ops that are fairly sophisticated on this right now, and that do some of those things because they get a reasonable number of requests, order of magnitude of what constitutes a big request for them is more like 30 or 40 polls as compared to 300. So, just a couple of for instances there.
Thank you. Chris, I did have one follow-up question. I meant to, you mentioned that something about, I can't remember exactly what you said, but you said typically that co-ops would get, you're looking at something like 75 polls. Did you mean 75 polls per year or month? I wasn't sure what you meant by that.
And no, that's just typically a request that the size of request on a large one that we could handle internally with existing infrastructure. Where before you get above that, and we're going to contractors, then we, even having the availability of those contractors, that's where that gets to be an issue sometimes.
Okay, thank you. I meant to follow up by that, but there was a lot of people that were sharing right after that. And I know I've heard contracting can be an issue. Does anyone have any other thoughts on that particular issue, particularly in rural areas, maybe?
Yeah, Ben, this is Sean again, if I may.
Yes.
So just, getting a contractor on board is oftentimes, a 30 to 45 day process. So you're outside the window pretty quickly on that. If you don't have, an active program going with regular permits, you're going to have trouble getting a contractor's attention. And it's going to be a 30 to 45 day process to get crews on site.
The other thing I was going to add to that, Ben, was, and not to put too fine of a point on it, but I think what we're talking about is for, quote, high volume requests, it really needs to be sort of a much different standard for the co-ops.
Sure. Okay. I was going to move on down to the additional topics that were suggested by charter, unless anyone had any other comments on what we've been discussing with those numbers. And the first, topic that charter had suggested was basically the pole replacement formula. And to be honest, I know we talked about that a lot last time. And I do understand the issue or the proposals with respect to where a pole is being replaced solely due to capacity. And I understand, the suggestion of using the main rule and things like that and how that works. I did have one just quick follow-up question just when I was looking back at stuff. I know a lot of the pole owners had suggested at the last meeting that if they go out to inspect the pole and, there's something wrong with the pole that like it's rotted or something like that, that's something that needed to be replaced anyway. That's not something that they would actually charge to the attacher. But there was and I think it might have been Kentucky Power and maybe some other owners as well, mentioned something, and you suggested adding some language with respect to costs of violations and I think cost of damage or violations caused by other parties. And so I guess I was curious. And you suggested including language basically that the pole owners will not be responsible for costs or caused by other parties. And how would you distinguish, like if you go out and you're doing an inspection of the pole, how would you distinguish if the pole's damaged or there's something wrong with it and it needs to be replaced? How would you determine that this is just something that, we'd be responsible for, we'll replace it, or this is something that was caused by some other party and not the new attacher, but some other existing attacher or something like that? How would you distinguish between those two things?
Well, Ben, I'm going to let Pam answer the technical question because I don't know the answer, but I did want to clarify what I think our request was, and I was having to think hard to remember what we said and why, but I believe it was in response to a proposed rule revision by maybe it was CTIA, maybe it was KBCA, I don't remember who, that essentially would absolve them from the cost of correcting violations caused by pre-existing attachers, which is not objectionable. I mean, we agree that they shouldn't have to pay for that. What we wanted to add to that, though, was the corresponding notion that it shouldn't be us that has to pay for that, the pole owner that has to pay for that either. So that was the specific ask. Pam, do you want to address Ben's technical question?
Well, before you do, Pam, I might just to follow up on your point, Eric. I guess I was kind of wondering, because there could be a distinction. I think I understood. I mean, I understand that obviously if someone else causes damage to the pole or that causes a violation that requires something to be fixed, like the pole owner wouldn't want to be made responsible by the reg for damage that someone else caused. But I guess I was curious, kind of like the order of who pays for it. Obviously, the new attacher didn't cause it, and I was wondering if the new attacher came in and was trying to attach, would a pole owner say, well, this pole's damaged and we know you didn't cause it, but we can't get these other people to pay, so we won't replace it? Or would the pole owner replace the pole and then seek recovery from the third party who damaged the pole to get recuperation of that amount?
If the pole was damaged and it's creating an actual safety or reliability problem, then the pole owner is not going to mess around with trying to figure out who done it. They're going to replace the pole. More often, though, the situation that the rule proposed by either CTIA or KBCA arises is where there's a clearance violation. And the controversy arises as to whether the utility, which say we can rule out that the utility was the cause of the violation. So we know it's not, if we know it's not the utility, and that it was one of the other attachers. What the new attacher often insists is that the utility pole owner cover that cost and then later go seek it. Well, if that happens, then the reality of the situation is that when the utility goes to that attacher that caused it, the other attacher says, I didn't cause that and it's already been corrected, so how would I even determine whether you're right? And that's the situation that Kentucky Power was seeking to avoid through its additional proposed language. It had less to do, actually it had nothing to do with damaged poles.
So Ben, to your question about how we would determine that, a prime example of when this happens is, let's say we find an attacher who has attached without approval, so they're unauthorized. I go out to engineer that pole. I start looking at pole loading and spacing, as Eric suggested, and I find, ABC cable has attached and I knew nothing about it. And when they did attach, they attached in violation. So I already needed a taller or stronger pole because of their attachment. I don't want to allow Charter to attach, creating even more problems until we get ABC cable to pay for the pole they should have paid for before. Does that help?
It does. I guess would the time, how would it happen that someone would attach without paying for the pole that they should have? I guess how would that situation arise? I guess who would be responsible for determining that, a new pole should have been attached, or a new pole needs to go in because there's not going to be enough clearance once you attach, but yet no one necessarily caught that, and therefore they were allowed to attach, and then someone else comes in and then it's caught. Who would have been responsible at the outset to make the determination that a new pole would have been necessary?
So had that attacher come to us and said, I want to attach to your pole, we would have done the engineering and said, you can attach, but it's going to cost this. We're going to have to change out the pole. Instead, occasionally, not always occasionally, but you have some bad actors who will just attach to avoid those costs. And we find them in our cyclical inventories. So we find unauthorized attachers and we can back bill them for the rent that they skipped, but they're not paying the engineering to bring that pole up to spec today because they're already on the pole. It's not like we're going to go cut them down because I don't know if 911's going through that. So they're already on the pole. If I try to tell them I have to change out this pole because I found you unauthorized, getting them to pay is not going to happen. So typically it's the next guy comes along. We need to change this pole out. It's going to slow things down, but it was because of this bad actor earlier.
Okay. Does that situation where the pre-existing violation, does that ever occur? Would you consider it a pre-existing violation in a situation, and I don't know if this occurs, but when they attached, the clearance was okay, but then the clearances, I'm assuming the clearances would be grandfathered, but I mean, would the clearances change and then suddenly now that is out of compliance? And would that fall into this situation, or would that be a situation where it wasn't considered a pre-existing violation?
The only thing, as you said, it would be grandfathered. The issue could become an existing attacher. They've got additional sag at midspan, so the clearances aren't maintained. So that would be what I would consider a pre-existing violation.
Okay. Did anyone else have any other comment on this topic? Just the pole attachment topic generally, or what we were discussing?
This is Chair Ben, this is Jeremy with Duke. Just want to kind of follow up with what Pam said, because we experience the same things, and that happens. You know, we just did an inventory and we found, you know, without getting into the specifics, there's lots of unauthorized attachments that we found throughout the state of Indiana. We did an inventory back in 2018 in Kentucky, and we found issues like this all over the place. So it's not uncommon. You know, for the small ones, the big ones, it's just, you know, it might not be everybody within that company that doesn't follow the rules, but there are the occasional bad actors that just, you know, they get a customer that needs service and they're going to go out and do it and bypass whatever rules they need to do to get the job done. So it's something we continue to see as a pole owner.
Thank you. Any other comments on this?
Well, I just want to make sure that we're still talking about the same thing. I certainly, Charter and the association don't think that we need to be protecting any bad actors, but in terms of the specific issues that have been raised, those seem to be already addressed by other parts of the regulations related to unauthorized attachments and safety violations and things like that. And certainly no one is here arguing about attachers bearing costs that they cause. But the discussion that we intend to tee up, and I just want to make sure that we're not going to blow past it without focusing on it, is really about pole replacements. And I don't want to belabor or repeat what we put in our comments or what I had said during our last session, but I do want to emphasize that the pole replacement issue is not a rate issue. It is an access issue and it is a make-ready issue. And for those reasons, it is in the heartland of what this proceeding is all about and goes to the purpose of what the commission is up to here in looking to promote ways to advance broadband deployment in rural areas. So I do want to make sure that we have fully joined issue in this conversation and that the commission has what it needs from us and everyone else in terms of information to make a decision on this. But I do want to make sure that we do close out this conversation and don't blow past what we had identified as a very important issue for us.
No, I understand. And whatever other comment you want to make, I guess, because we had discussed that last time, and I'm not, I think I fully understood everyone's position on that last time. But I mean, if anyone wants to make any other comment, feel free. I'm not trying to discount it. I just had that other clarifying point that we hadn't really discussed last time. But I definitely understand both sides' position on that, the broader issue. It just, because we discussed it last time, but if you have something you wanted to add, feel free.
No, I don't. I don't want to take up everyone's time with arguments we've already and issues we've already put on the table. So thank you.
Thank you. And I might skip number 2 and come back to it just in the event that we run out of time. But because we did discuss the itemized invoices. So this other is whether Section 8A should be, or which allows poll owners to deviate from make-ready timeframes for unrelated alleged breaches. And this had to do with basically breaching the tariff. Is that correct?
Right. That's right.
And I think
we just want to make sure that attachers aren't jammed up on issues that are really unrelated to access.
And I understood your all's point on that. I mean, I believe that most likely, I think the intent there was to basically say, there's going to be conditions and things in the reg with respect to how you gain access and the contracts and things. And if you don't comply with those, then you're not permitted to attach. And I guess your all's concern was that there might be some unrelated issue, and that it should be limited to kind of the complying with the access conditions, basically. Is that correct?
Yes, exactly. And this is based on our real world experience where there may be an outstanding invoice or some other unrelated contract issue, and we don't want issues like that to stand in the way of our ability to get access to a poll. And they shouldn't. Those are corollary issues that should be resolved in the normal course, of course, but in other ways, and they shouldn't be a basis for a utility to deny access.
I think that was probably the intent. I don't know. There might be some nuance. Does any of the poll owners have any comment on that, clarifying that section to make it clear that it's talking about complying with the access conditions?
Well, Ben, I don't think this issue, this is Eric Langley speaking, I don't think this issue was raised in the written comments. I think the record is pretty thin on this, but we do think that there are a variety of circumstances under which things could and should come to a halt. And if what the attaching entities are trying to frame as a scenario where, regardless of whatever breach or default they are in under the tariff, they can still press forward with access, then no, we don't agree with that at all. I mean, there has to be some teeth. This isn't the Pirates Code. This isn't just a set of guidelines in the tariff. It's supposed to be a real binding agreement, a filed rate, in fact. So we think that the way the commission framed the proposed rule in the first instance, and to which nobody, to my recollection, objected in the written comments, is the right one.
And this is Jill. I'd like to kind of follow up on what Paul said and sort of what Eric's saying. As Eric and I and Paul, we all work together a lot, and a lot of times we have disputes with each other, and a lot of times those disputes take a long time to work out. And often a poll owner will just hold up our jobs until that dispute is worked out. And that gives the poll owner a lot of leverage over the dispute because our whole business is at issue. And there's plenty of remedies other than holding up a permit that we can be in default. I mean, there's so many other things they can do under the agreement that having that any breach or alleged breach normally associated with the permitting process is really problematic.
This is Tip. I might just weigh in because I've got real world experience with Paul's firm on litigation about this very subject. And, you know, it's certainly not my experience that the agreement provisions regarding default have been deemed convincing by the attachers. So we wholeheartedly support Eric's views.
Any other comments on this? So the next one is whether or not we should incorporate a new section that incorporates the SEC's overlashing rules. Let's see. I think at least some of the poll owners were okay with that, so long as there were some things added. Am I correct about that?
Ben, this is Eric. I think that that is correct if we are talking about what KBCA proposed, which was different than the actual FCC rule. So
okay,
just to make sure I know what we're addressing. If we're addressing KBCA's proposed rule, yes, we were fine with the majority of it. We had asked that one sentence be deleted and one be added. But if we're talking more broadly about instead using the FCC's overlashing rules, which are different than what KBCA proposed, and we would have a handful of other comments.
Okay, I didn't recognize that those were different. I guess the charter went in, like, what were you proposing here?
We were only proposing that we close out the discussion of what we had put forward in our comments. We're not looking to reopen the discussion or supplement in any way.
Okay. So you're referring to what you had written and what Eric's referring to also.
It seems that we're on the same page and that the utilities are largely in line with what we had proposed.
And are you all okay with their proposed changes?
You know,
I think it's
honestly,
in the Bond's comments.
yeah, Ben, I don't remember. We'd be okay with following the FCC rule to, exactly. If that's what Eric is saying, then we'd be okay with that.
Well, no, what I was saying is that if we're talking about implementing the FCC rule, then our comments would be different than the ones we have put into the record addressing the rule that KBCA proposed.
Well, Eric, perhaps you can
proposed
remind
specific
us.
language.
Yeah.
And then it included, I think, one of the sentences, the sentence that I think Kentucky Power had an issue with, it they included, that overlashing be allowed, and then upon notice, and then indicated that such notice requirements may not include any quasi-application or quasi-approval requirements, such as requiring engineering studies or requiring attachers to pay for utilities review of the planned overlash. And that was a sentence that Kentucky Power deleted, indicating that they wanted that sometimes that would be required for overlashing.
But that's not the FCC rule. So the FCC rule specifically has that language in the order that rejects them from requiring engineering studies and making it a quasi-application. They made that very clear in their order. So that's why we put that language in there. It's not in the rule necessarily, it's in the order. And that order was upheld by the Ninth Circuit.
Yes,
So
and then,
Go ahead, Eric.
then this is kind of highlighting the issue that I'm having here. What are Kentucky Power and LG and EKU addressing? Are we addressing what KBCA proposed? Are we addressing the actual FCC rule? Or are we more broadly addressing what the FCC has said in orders adopting the rule, but with language that is not actually in the rule?
I mean, I think we're addressing the KBCA rule at this point.
Okay. then the sentence that you pointed out, and this is the position of LG&E, KU, and Kentucky Power, not just Kentucky Power, would hamstring their ability to actually do the engineering for overlash. Overlash isn't exempt from the laws of physics. It places a burden on the pole. The electric utilities need the opportunity to evaluate it. If there's a cost associated with that evaluation, it's a cost that the overlasher should pay. It's really that simple from our perspective. We agree with KBCA that the process for overlashing should be more streamlined than the regular application process, and so we don't object to the 15-day advance notice protocol.
Okay.
Well,
You just want to be able to do the engineering costs, and then if necessary, and then the attacher would then be responsible for that cost, correct?
That's right.
Are we talking, this is Jeremy with Duke, are we talking about this from a perspective of from distribution poles only? I don't think Duke wants to loop transmission poles in with distribution poles on this.
From KBCA's perspective, it would apply to the poles that are subject to the regulations, not other facilities that Duke or others may have.
Okay.
but just in terms of the engineering, the reason the FCC doesn't require it is because they don't believe it's necessary and that it was imposing a lot of costs and delay on overlashing. So, you know, that's in the order, and that's why we made it part of the proposed rule. So I just want to make sure that's understood. It's a huge burden on lightweight fiber overlashing to do engineering studies that are not necessary, and that's why the FCC rejected it.
From a Kentucky
Respectfully,
power-
Jill, this is John. Sorry, go ahead, Pam.
I was just going to say, from the Kentucky perspective, regardless of how small you think that what your overlashing is, it still has impact on the pole. It has impact on the spacing on the pole and the loadings, the tension. There's so many other engineering requirements that are involved. You cannot, as Eric said, you can't deny the laws of physics. Yes, the FCC ignored that, but as I've said before, in many cases, there is no E in FCC. They don't understand the engineering impacts of what this is. John?
Thanks. And I agree with that, Pam, 100%. I mean, most of the people on the call are familiar with the Ike and Ice disaster back in 2008, 2009, where we had a huge number of poles break off at the telecommunications attachment. Even though we have a small fiber, when it's lashed to a 2-inch diameter or greater in many cases, bundle of cables, that increases the surface area for ice to freeze on and drag the pole down. So it does pose an engineering concern. That said, Joe, I disagree that it's a tremendous burden on the attaching entities. At least for LG&E and KU's part, we don't perform or require a pole loading study on every pole. For overlashing, we don't require that a pole loading study be submitted as a matter of course. But it's critical for the reasons that I've just described and for others, that LG&E and KU and other utilities have the opportunity to perform that engineering review, even if it includes a pole loading study on every new piece of every new facility that's going on to our poles. It's not required every time, but we do need that option for when poles appear to be overloaded or close to make sure that we continue to provide safe and reliable service to our customers.
Duke Energy would agree with that.
And if you're keeping score, the co-ops are in the same camp with the other IOU electrics.
Thank you all. Any other comment on that issue? Okay, I'll go on to this next issue, which is these are all issues suggested by charter. It's whether attachers should be allowed to use self-help in the electric space, as section 5.1 currently requires without resort to a complaint. And I thought we discussed this somewhat at the last meeting. But if you all want to provide any further kind of comment on that, we would obviously welcome that.
Again, I think this is just an area where we wanted to make sure that the issues had been fully joined, and our position, consistent with the way we've teed up the issue, is that attachers should be allowed. The FCC has addressed this issue, courts have addressed this issue, and they've found that attachers should be allowed to perform make-ready in the electric space and use self-help to do so when necessary.
The only thing I'd add to that is, of course, the FCC's jurisdiction over these just generally does not extend to cooperatives. And you've got different circumstances in cooperative territory that need to be considered. And if we want to have safe electric systems, we need to allow it to remain as it is.
Yeah, but I mean, if this had been the long-standing practice of the FCC and there was significant experience with it in the industry and people understood its contours and it had been demonstrated that it could be done safely, efficiently, and without disturbing electric service, that would be one thing, but that is not the case. This is a very new rule adopted by the FCC. It just took effect in spring of 2019. So Paul will correct me if I'm wrong about that. And over a great objection by the electric utilities. The fact that the FCC adopted it and the courts affirmed it doesn't mean that it's correct as a matter of good engineering and good system management. It only means that it passed administrative review. So, I mean, we've explained in our written comments why we think this is a bad idea. And to also put a finer touch on this, there are some circumstances where electric utilities will allow it. But where that occurs, it should be done through either special contracts or, like in LG&E KU's case, through the tariff that provides additional safeguards on this process. So to be clear, the objection here isn't so much that it might occur from time to time with the permission of a specific electric utility, but the conditions under which it occurs and how that very sensitive and frankly dangerous work is performed and managed.
Thank you.
Well,
Anyone else have any thoughts on that?
I was just going to say, the rule does require us to use your contractors, your chosen contractors. So without the ability to perform self-help in the electric space in those few circumstances using your contractors, that undermines the whole point of this, proceeding, which is broadband, efficient and timely broadband deployment.
Well, I'd say that number one, there's a big difference though when the work is being performed per a regulatory right versus when the work is being performed under a tariff or a special contract that places additional contours on how that work is performed. The second thing I'd add is I think we just had a conversation earlier about contractors and the extent to which the pole owner could exercise control over who those contractors were and what requirements there were for adding new contractors. And so all these things are interconnected, and if there's going to be any ambiguity at all surrounding how the work is performed or who performs it, this is just not acceptable from electric distribution system management perspective.
Well, as in the FCC rules, you have total control over those contractors and you could set the limitations on how the work is done. It's just really a matter of timely make ready and being able to deploy and provide services.
I'd just like to add, I don't think this commission should discount that the FCC has adopted this approach. The FCC dug in and considered this issue. It has a lot of experience in pull attachments, and it did promulgate this rule. It was upheld by the court, and it has been working in practice now for years. And to Eric's point about there is some difference between whether this is mandated by rule or adopted by parties. There's no functional difference other than, as Eric pointed out, that there may be other practical considerations that need to be addressed, and those will be worked out through tariffs or agreements. So having it as a baseline does not mean that there cannot be other implementing considerations by utilities. There can be, and we've discussed that earlier in this conversation, and all of us have commented on that in terms of the existing proposed regulations.
Thank you. If no one had anything else, I was going to move on to the next topic. And I was going to skip, we're on number 6, but I was just going to skip to 7 really quick because I actually did have some questions on this one. And that was whether section 7.2 should be revised to require the commission take final action on an access complaint in 90 days rather than 360. And I know at least some of the poll owners indicated that if it was an access complaint, they were fine with the 90-day deadline. I guess, are there any poll owners? Well, I guess I did have a question, and perhaps this was addressed in a comment and I just can't recall it, but and I think it is addressed in the FCC rule, but I do not remember that either. But what would a poll access case, what would define that as opposed to some other type of case?
This is Jill from Charter. That would be if there was an unreasonable denial of access. So for instance, maybe the parties disagree that there's insufficient capacity or there's a safety, reliability, and, applicable engineering reason or something like that, versus a violation of the time frames or a rate rule or something like that. So it's really just the access standard, whether there's an
So there's been a denial of access, and whether or not that denial was reasonable is basically what the complaint would be addressing.
Exactly. Is it based on sufficient evidence, stuff like that. That's how we would distinguish it.
It seems like there's somewhat broad agreement, but then there's the question too of the capacity of the commission to address them within 90 days also. Which,
Understood.
Depending on how many of them we get. Did anyone have on the 90 day?
I'm sorry.
Go ahead, I'm sorry.
It was LG&E, KU, and Kentucky Power that proposed the definition of pole access complaint, and it was the definition, I think, verbatim from the FCC order that adopted that expedited shot clock for access complaints.
Okay. And LG&E, or did anyone else have a comment on just the 90-day timeline for access complaints generally? I did have one other question about it, but if not, I did have, so LG&E and KU and Kentucky Power, I think, also suggested that if we were gonna go ahead with that there will also be a requirement that the parties have executive level discussions to attempt to resolve the complaint before filing it. And I had a question for the attachers in that, what your all's position on that suggestion would be.
This is Jill from Charter. We have no issue with that. I think that just happens in the normal course anyway, and no one wants to file a complaint case. That's really the last thing you want to do. So I would have no issue with the executive level discussions prior
I think
to
the
filing.
whole attachment complaint case we've had it resolved. Once they were filed with the commission, they then resolved either at a status conference or even before, so. Go ahead, I'm sorry, I didn't mean to cut somebody off. Okay. Did anyone else have any other thing they want to talk about with respect to complaints? I was going to go back up to the ones that we skipped really quick. And this was another, Carter's, I guess, number 6 here. If you all want to comment on that from Charter.
Yeah, thanks, Bill. This is Ben. This is Jill from Charter. This isn't a huge deal, but I feel like something like this, a notice period, as you put in the proposed rules, should be standardized throughout the state. And we shouldn't have to deal with each separate utility on a tariff by tariff basis. This is a pretty standard 60-day for non-make ready removals and transfers is pretty standard around the country. And I don't see any reason why there has to be a different rule for every single utility in the state.
Does anyone have any other thought on that issue from a poll owner perspective? Okay. I guess I was going back to this itemization issue, which was kind of a follow-up to last time. Was there anything in particular you all wanted to bring up from Charter with respect to that issue?
Yeah, I think we all felt like we came away with that with not really kind of finalizing that conversation. And we just wanted to sort of reiterate the need, especially for a make-ready estimate, where we're trying to decide whether, to build on a certain pole or not, or to, if the make-ready costs are too expensive. We really need some specificity in order to make those decisions. They're business decisions, and we can't just have one line item. This is what the make-ready is. It really needs to be a little more detailed than that. With regard to requiring it on a pole-by-pole basis, that we would not do every time. And in the rule, it says as requested. And, we wouldn't normally request that, but we just kind of wanted to button up that issue and just sort of reiterate that, Charter is reasonable. We wouldn't ask for, highly detailed invoices on every single invoice, but that we think the rule is important in order for us to carry on our business and be able to tell what we're paying for.
When you state, this is Jeremy with Duke, Jill, when you state itemized, what is Charter's view of an itemized bill? What does that look like?
Well, I don't have the construction guys on a phone call, unfortunately, today, but I think sometimes they get bills that are just, this is what the make-ready is. They don't know whether, how much a particular pole change-out cost will be, what the make-ready on a specific pole is. I think, you're writing up the invoices based on what make-ready work you think would be required. And so I think it would be possible for you to come up with a line item on, at least on each pole, what make-ready work needed to be done and how much that cost. Or at least, a flat cost for this or that associated with the make-ready. I think it's just difficult sometimes for them to know what they're paying for and how to evaluate a project.
And the current reg does say to the extent
Yeah.
that you're able to do that. That's it.
Right.
So I just trying to get an understanding, because I think, at least from Duke's perspective, that's something that we already provide, but I just kind of want to get a better understanding what you're saying. So is Charter getting a make-ready estimate for, let's say it's a 40-pole job, and it just says make-ready estimate, and you don't know what it's related to as far as the poles or anything at all. It just says make-ready estimate. It could be anything along that 40 poles. You don't know.
That's right. Sometimes we get just sort of a big number. And this is what the make-ready costs for this project. And some of the utilities have rejected the rule of a detailed itemized invoice. And that's in the proposed rule, and it's in the FCC rules, which, Duke follows in other states. So, we just weren't sure of the objection, really.
Well, our objection, I know from a detailed itemized, is that we don't want it to be broke down to every nut and bolt, which we've had requested from a couple of communication companies. And that's, I think you're getting in, if you could require every nut and bolt, you might get into contractual issues on things of cost and nature that we should not be getting, should not be providing. So I think from our perspective, a detailed itemized to that level is not necessarily needed for a communication company to determine if they're going to do make ready or not.
And I don't think charter would ask for every nut and bolts. I think that, as Ben pointed out, it's as calculable. So I think it's really the work that needs to be done.
Sure. Okay. Yeah, thank you, Jill, because I was just trying to get a better understanding for me, just to make sure I'm thinking through everything correctly.
And I had asked about this last time, and someone had mentioned this because, I'd asked about it to kind of see if there was an issue where, obviously, if someone requested a pole-by-pole basis every single time, that could get kind of, overwhelming, I imagine. But from the discussion that everyone had last time, it seemed like that was not really an issue where people were requesting a pole-by-pole basis all the time.
Right, that's what our construction folks said. But sometimes they just needed more detail, and they would like the opportunity to be able to request it.
And Ben, this is Allison for Duke. I think that our comment on this just said that maybe we should insert the word reasonably in front of detailed so that it doesn't look like that we have to give every nut and bolt in the estimate. When you say detailed, I mean, that pretty much goes down to the very minute details.
I'm sure we can live with that.
Okay. Thank you all. Any other comments on that? Okay, was there anything anyone else wanted to address before we signed off? I think we've hit all the topics on the agenda.
Looks like your all skills as goldfish farmers should be commended. 13.
I think we all have Mr. Perry to thank in his previously scheduled meeting. I was going to thank him for doing so. All right, so I think the next step is we're finished on this one regulation with the informal public comment on this. And so what staff will do is that we'll huddle together and see what changes, if any, we will make to the proposed pole attachment regulation and take those changes to the commissioners and see if they agree or if they want additional changes from that. And then the step after that will be when we file it with the Legislative Research Commission. I have no idea of a timeline on that, so I can't commit to that. But those of you that have gone through the regulation process knows that once if it's accepted for filing, meaning we have all the T's crossed and I's dotted and texts marked in the proper way for the LRC, is that we will then post it and we'll have another opportunity for comment and for a public hearing, after which the commission can choose to amend its proposed tariff further to reflect the comments that were made, and then go back to the LRC, and then it will go from there through a legislative hearing, and then at some point, if all goes according to plan and the planets are in the right alignment, it will become effective at some point. So that's where we stand now, and I will alert the people who are on the regulatory email list when we are heading down to the LRC to make the filing, just so that you all will know. And once it's accepted for filing with the LRC, we will post a copy of it on our website, and I'll also send it out, a copy of it, to the people on the regulatory email list. All right, any questions about that? Okay. All right, are there any last issues that people want to discuss? I'll give you 1 minute, and then I'm just going to have the button pressed. Okay. Guys, thank you so much. I really appreciate this. I want to give a special acknowledgement to Ben. He's really carried about 99% of the water on this entire thing, and I really could not have done it without him. So there you go. Anyway, everybody have a good day. Chris, good luck in your meeting. See y'all.
Thanks, everybody.
Thank you.
Thank you. Good night.